I know, just for starters.
Yeah.
Check.
to me is like I use it well, but I don't think it was my answer. No, I don't. So French wearing black is like in between ushers, and so it's over those.
Yeah.
Yeah. So I actually asked. People was asking that.
Good morning.
Looking forward to getting started. Thank you.
I'm just trying to examine this, whether this walking path is a problem with the camera here. I think that's not quite a success.
Yes. I've been yes, I haven't been. I know. Are we good? Yeah. Are you? Good morning. Good morning, everybody, and welcome. Whether it is your first time stepping onto Vermont Law School's campus, or whether this is a location that you visit every day, welcome. The Symposium, Criminal Culpability, Who Deserves Punishment, brings us all here together at a unique place and time. Currently, the United States has the highest incarceration rate in the world, while we're home to only 5% of the world's population. We house 25% of our returning citizens. And additionally, Vermont, which is a place that is very near and dear to my heart as my home state, despite our beautiful foliage and idyllic scenery, we're battling our own challenges against opiate addiction, trying to find the best way to invest in rehabilitation and transitional housing. So rehabilitating our nation's criminal justice system and restructuring sentencing reform, those are topics I'm going to leave to our panelists for the day. And the panelists that you have today, you're going to hear from, represent the textured face of criminal justice reform. Prosecutors, defense counsel, professors at the forefront of their field, and policymakers. Thank you all to all of our panelists for being here today and for joining us. It's going to be a great conversation. But before I turn you over to today's discussion, I want to thank somebody very special who isn't here today. And that person is Christine Billis. Ms. Billis is a hairstylist, and she's an outstanding debater, and she's an artist. And it is her artwork that you see featured on all of our promotional materials. So Ms. Billis, in addition to all of those things, is also incarcerated at the Chittenden Regional Correctional Facility, which is Vermont's sole all-female correctional facility in the state. Ms. Billis, along with other folks from Community High Schools Vermont at the Chittenden Regional Correctional Facility, and folks from Northeast Correctional Facility and Mill River Union High School, all contributed to criminal culpabilities for this year. And so all of the artwork that you see out in the hallway has been donated from them. It was a fierce competition to choose the winner. I hope you'll take the time to check it out later. Each of those folks wrote a statement as well, and they feel as though, in their way, they have been affected by the opioid crisis in this state, and additionally by the criminal justice system. And while they couldn't be here to participate on a panel, they wanted to make sure that their voices were heard as well. So please take the time. There's also places for you to write notes back to the artists. So I encourage you to do so because they took the time to put those pieces together and they're very excited to hear your feedback on them. Additionally, I would invite Mr. Howe to stand. Mr. Howe is from Community High School, Vermont, and he was part of the push to help get the art competition to folks, helped us to get art back and forth, and please ask him later on about some of his students. Thank you so much for being here. Thank you to Vermont Law School for hosting this event and giving Vermont Law Review a venue to bring together so many powerful voices. Thank you to all of the folks who contributed to making this event happen, particularly Candy and Kelsey, who have coordinated since February to bring us all here together. And thank you to you all for being here to join this dialogue. Welcome. Welcome to Vermont Law School. Thank you. Professor.
Good morning. Today being Symposium Day, it's also Constitution Day. So I wanted to take this moment to wish you and yours a happy Constitution Day. It's a day that honors the adoption of the U.S. Constitution and those who have become U.S. citizens. So 2 reasons to celebrate today. Welcome to Vermont Law School. On behalf of VLS, I want to extend a warm welcome to all of our visiting scholars and guests of VLS. We're so grateful to have you here today and to be a part of this symposium. I had a chance to meet some of the speakers last night at a dinner, and I learned so much just in a short meal that I know that today will be an exciting day for everyone in the audience. I want to acknowledge the members of Vermont Law Review who have put this day together, and especially Jessica Bullock, Kelsey Bain, and Catherine Spindler. I've been so impressed with the professionalism that these students have shown in organizing this event. There was a point last night when I was watching them network around the room, making sure every one of the speakers was comfortable, making sure that we were all having a good time. And I thought back to what was I doing the second week of my 3rd year of law school. And then I looked at them for a while and I thought, not that. Those students, those 3 students and many members of the law review really bring honor to this school every single day. And I suspect that one day we're all going to be saying we knew Jessica, Candy, and Kelsey once. Now, many of you know Vermont Law School as the environmental law school, and if you didn't know, composting toilets and solar panels and electric car stations would have told you that. But what you may not know is that we also have a formidable and growing criminal law program. It's led by professors like Professor Sand and Professor Taub, who you'll hear from later today, and it deserves some serious attention. We were recently ranked by the National Jurist as one of the top schools for prosecutors and public defenders. This recognition was based on our curricular offerings, our employment placement, our debt and starting salary for new graduates. The program and our many successful alumni practicing in the criminal law field fit perfectly and proudly into Vermont Law School's motto of law for the community and the world. And as does today's discussion. As Jessica told us, the United States has a larger prison population than any place in the world. And at the same time, many of those who cause the most harm are left unpunished or hardly punished. Another one of our mottos here at Vermont Law School is that the status quo is no longer acceptable. So it's no surprise that our students have put together today's event and brought so many great minds together to discuss this problem, to discuss the question of who is punished and why. We may not find the answers today, but it promises to be an exciting discussion and an informative day. I really want to thank you for being here, and I now want to introduce Kelsey Bain, class of 2017, symposium editor, and all-around outstanding member of the Vermont Law School community. Thank you.
Hi guys, Catherine, do you want to come up as well? And we'll do this together. So in the mess of organizing all of this, I haven't prepared anything super long, but also I think keeping it mercifully short will probably be welcomed. I want to thank you all for coming. I want to thank all of our panelists who have been putting up my emails and Candy's emails and organizing this whole thing. I really want to thank the Vermont Law School, or the Vermont Law Review staff for also putting up with me. Today would not have been possible without you guys, so thank you. We have a fantastic schedule lined up. It's up there. We're probably going to run a little bit late today, but I think it's worth it, so please stick around. We'll have lunch a little bit later, and then if anyone needs help with anything, please come find me. Candy?
Brilliant. Good morning, and thank you all for coming. As you've probably gathered by the comments that have come before me, Vermont Law School is a special place. We come here either like Jess, residents of Vermont, or individuals who for a few years are going to take up the state as our home, while we allow it to nurture our thirst for legal knowledge. And being Vermont's only law school puts us in a unique situation. We not only have the ability to effectively look around us and see the issues we see in our state, but we also have the capacity and perhaps obligation to address that. And one of the most powerful ways that we can do that is by bringing together powerful minds. As you will see today, a good amount of those powerful minds are gathered here today in the form of our speakers, who through their expertise and experience will be able to talk about things such as drug reform and white-collar crime in a way that offers a diversity of opinions. But there are other powerful minds at play as well. We also very much encourage you to look at the powerful minds on display in our hallway that represent the voice of our state's children and also incarcerated individuals and address their thoughts and feelings on the subject as well. And among the other powerful minds here today are you yourself as audience members. You in your capacity as students, teachers, attorneys, brothers, sisters, daughters, wives, and most importantly, voters, have the incredible power to not only harbor your own thoughts, but vocalize and share them. Today, we encourage you to do exactly that by listening to our speakers, participating in the discussions, and taking these thoughts and the ideas that you form back to your home. Right now, as Jess did address, we do face an opioid crisis in Vermont. And we encourage you to think creatively and thoughtfully you can address the crisis and bring about effective change to our state. Today, I hope you enjoy. Nothing that is occurring here today would have been possible without the efforts of some very important people. Chiefly Professor Taub. We would not have been able to do any of this without your experience and guidance throughout the entire process. We are very grateful. And furthermore, Professor Sand has been incredibly helpful and instrumental through his own experience and guidance. And here at Vermont Law Review, we also believe that powerful ideas and powerful discussion require equally powerful coffee and delicious food. And for that, we would also like to thank Jed and his team at the Fox Stand Inn. We are very much appreciative of your delicious, delicious beverages and pastries, and we look forward to lunch. Thank you so much, and with that, I'll turn to Professor Taub. Thank you.
So thank you, Candy, so much for that really kind introduction. And I promise all of you I will be brief, notwithstanding my past speaking history. As we begin the day, I'd like to invoke the memory of someone who is not here with us, but I believe greatly influenced this event. And that is Edwin Sutherland. About 77 years ago, in December 1939, Sutherland coined the term white-collar crime in a paper he delivered. This was for a joint meeting of the American Sociological Society and the American Economic Society. He defined the term white-collar crime to refer to a crime committed by a person of respectability and high social status in the course of his occupation. He stated that the thesis of his paper was that the conventional conception and explanations of crime are misleading and incorrect. His goal, then, was to make a, quote, comparison of crime in the upper or white-collar class composed of respectable, or at least respected, business and professional men, and crime in the lower class comprised of persons of low socioeconomic status. Of course, the term has evolved over time and grown to have broader and multiple meanings in the legal arena and public sphere. Like Sutherland, the students at Vermont Law Review have organized this event to make comparisons and to challenge the conventional wisdom. Accordingly, our panels will explore 3 provocative questions concerning criminal culpability. First, does criminal law disproportionately punish drug offenders? Second, does criminal law go easy on white-collar crime? And lastly, a policy question at the end of the day, where should criminal law focus its attention? Also at lunch, our keynote speaker will talk about his forthcoming book on white-collar crime called The Chicken Shit Club. I'll leave it to him to explain the title. I will now invite up our first panel, led by Professor Bobby Sand, to come up. And in the words of my favorite character from the musical Hamilton, Angelica Schuyler, I leave you to it.
Good morning. As a graduate of this incredible institution and a former managing editor of the Vermont Law Review, it is a great honor to be the moderator at this first panel. I still have the quill and parchment that I used to write my law review note some years ago. So this first panel looks at the question of whether drug offenses and drug offenders are punished disproportionately harshly as compared to others within the criminal justice system in general, and then more specifically as compared to so-called white or bright-collar offenders. Before introducing this incredible panel, let me give some context to that discussion and perhaps set up an anticipatory point of contrast to what you may hear. Students of criminal law know that we have 2 principal theories of punishment in this country. The retributivists say that we should punish people who commit crimes because they deserve consequences. Blameworthy behavior is deserving of a response. The utilitarians, in contrast, look to the future and say that the only reason to impose punishment is to serve a social value, to create a net improvement in public safety, a net reduction in harm. We know as well that there's no obligation to follow either one of those 2 theories consistently. And importantly, subject only to some limitations created principally by the Due Process Clause and the prohibition on cruel and unusual punishment, state legislatures and Congress at the federal level have extraordinarily broad discretion to decide what conduct should be deemed criminal and to set the maximum penalty or the penalty range for violations of that criminal conduct. So against that background of extraordinarily broad legislative authority to define crimes, let's look at the issue of whether drug offenders are punished disproportionately harshly. So I will briefly introduce our 3 panelists. You can find out more about their background in the conference material. When I'm done, each of them will have 10 minutes to tell you some more about themselves, what they're doing now, and their views about the disproportionality of drug punishment. After that, we will have an opportunity for some dialogue, and if there is still time remaining, we'll take a few carefully worded and concise questions from the audience. So, to my immediate left, Professor Ekow Yankah. Professor Yankah is a professor at Cardozo School of Law. His scholarship has appeared in a variety of books, law reviews, and peer-reviewed legal theory journals. He has also been a distinguished visitor at the MacArthur Foundation. His current work and forthcoming book explores Republican theories of political obligation, grounded in civic duty and its relationship to law generally and criminal law in particular. Professor Yankah has been recognized as one of the top 50 influential law professors under 50. He serves on the executive board of the Innocence Project and American Constitution Society's New York chapter. His opinion pieces have appeared in, among other places, the New York Times, the New Yorker, and the Huffington Post. Please welcome Professor Yankah. Of our panelist, Jeremy Haile. Jeremy's portfolio covers a range of issues, including sentencing policy, racial disparities, and mass incarceration. Mr. Haile was instrumental in passing bipartisan legislation signed into law by President Obama to protect lawyer trust accounts that fund legal aid. He has maintained a deep interest in criminal justice policy since making regular visits as a college student to prisoners outside of Abilene, Texas. Since joining the Sentencing Project, where he serves as federal Advocacy Counsel, his work has appeared regularly in the media, including the New York Times, the Washington Post, and NPR's All Things Considered. Please welcome Jeremy Haile. Lastly, to the far left, at least geographically, Professor Mark Osler. Professor Osler's work advocates for sentencing and clemency policies rooted in principles of human dignity. He writes on clemency, sentencing, and narcotics. His writing on clemency, sentencing, and narcotics policy has appeared in the New York Times, the Washington Post, and numerous law journals. A former federal prosecutor, he played a role in striking down the mandatory 100-to-1 ratio between crack and powder cocaine in the federal sentencing guidelines by winning the case of Spears versus United States in the United States Supreme Court. With the court there ruling that trial judges could categorically reject that 100-to-1 ratio. He's testified as an expert before the United States Sentencing Commission and the United States House Subcommittee on Crime, Terrorism, and Homeland Security. Please welcome Professor Osler. Gentlemen, let me suggest that you speak in the order of your introduction. So Professor Yankah first, and feel free to grab the podium or stay seated as you prefer.
If everybody's okay with it, I'm happy to stay seated. So first, I want to sort of thank the two young ladies, two young ladies in particular, Kelsey Bain and Candy Spindler, I believe, and all your staff. I know how hard it is to make things look easy, and you've done a remarkable job shepherding academics, which is its own. In particular, this name showed remarkable patience for my schedule, which is weaponized. I do want to add a comment to this. Lots of people will tell you how great these young ladies are. You should be a little suspicious. I understand that talented young students are actually coming for our jobs, so I don't congratulate them with perfect ease, but we'll be honored when they take them, and the book will probably be in better hands in any case. We've been asked to spend a few minutes, so I want to make sure to keep the time. So we've been asked to spend a few minutes speaking about how we got here, how we got I'm not going to tell you how I got to Vermont Law School, which is very beautiful, it's somewhat remote, but I think you're going to more, it is very beautiful. I think you're going to more generally how we got to our place in life or so. It's been, for me, it feels a bit odd, but I actually remember being in your seat, so maybe it is helpful to remind students that there is life and jobs after law school. It's a challenging time. So let me first say that unlike the talented students in front of you, I didn't have it figured out when I was, I mean, never mind my second year of law school. When I graduated, this may provide some small comfort to some of you. When I graduated, all my friends had very fancy jobs, lined up in very fancy institutions, and I felt like I worked hard. I had some successes, some failures, and I didn't have one of these jobs. And I, to be really honest with you, had real bouts of self-doubt, and real, I didn't know what was wrong with me, why was I a bit lost? I knew I was a bit lost because the things that were on offer weren't the things that I loved. And it turns out that's okay. You don't want to be lost forever, but it turns out that I'm going to tell you just one small trick. People tell success stories backwards. You have to remember this. They're lying to you, right? They don't mean to, but they're lying to you. So Nelson Mandela, you can pick somebody, but there are not people I admire much more than Nelson Mandela, right? When you tell the story of Nelson Mandela's life, it looks like he was inevitably heading to be Nelson Mandela. When Nelson Mandela was being put into Robin prison, he was just some guy. I mean, that's not quite true. He was a remarkable leader. It's not like Nelson Mandela knew what the future held for him. He didn't know he was going to become Nelson Mandela. He was presumably terrified, like the rest of us, and thought, I might not make it, right? When you see your law professors, it's easy to think, oh, yeah, they were born law. No. No. It's not the idea that everybody else is inevitably headed to success, and you're the only one who doesn't know what's going on. Is a myth. It's only because after they're successful, we tell the story backwards. It's also true about failures, by the way. It's something we should remember as we talk about prisoners. It's not that their lives were fated to be not successful. There are choices that they made, some of which deserve real condemnation and punishment. But there are also choices that we made about how their lives turn out. But I don't mean to digress. Anyway, to be much more quick, graduated from law school, didn't know what I was going to do. So professors pulled me aside and said, what are you going to do? I said, Professor, I'm going to get a job, because that's what people do. The professor said, you should get a job. So I was very, very blessed. Some professors of mine approached my dean at my law school and said, we think you should be something. Do something. My dean said, that's fine, do that. Because what deans know is that if they take care of each professor's pet student, they'll have to take care of every professor's pet student. So the dean rightly said no, and my professors insisted, and eventually they gave me a fake title with very little everything, but it allowed me to be a fellow at my law school, which is remarkable. So I spent a year writing, and while I was writing, another professor visiting from my graduate institution was visiting, and towards the end of the year, he said, what are you going to do next year? I said, no. I've been through this before, I'm going to get a job. And he said, that's a shame. You really, really enjoy graduate work. Anyway, fast forward, I ended up doing graduate work. And when the third time they asked me what I was going to do, I said, look, people, I'm missing out on luxuries like food. So I ended up practicing for 3 years at a small law firm named Boyce, Schiller & Flexner. It was a terrific little law firm, and the joy of it is that it's a little law firm. By the way, all this I want you to keep in mind that 2 years before I had been totally lost and didn't know what was going to happen to me. And Boyce Schiller is famous for lots of things. I ended up working on what is still to this day the largest lawsuit in U.S. history. It's U.S. v. Philip Morris. It's just you and your friends fighting over $800 billion. Keep in mind, when you're fighting over $800 billion, lots of lawyers end up working on this case. It's not like I was the advocate. But it was a remarkable experience, and it was remarkable because it's a very small law firm, so I got to be a lawyer fast, which was great. In the middle of all this, once again, somebody approached me about teaching. I'll skip the story, but the point is just, once I was finally offered a teaching position, I always tell people it's like dating somebody you like and meeting a girl you love. I really like practice. I really enjoyed it. Once I knew I could be a teacher, that was it for me. And so I started teaching and made the transition to being a philosopher. And among the joys of my job has been the way in which I slowly have learned to mix in the writing both to my colleagues in dusty legal theory journals, which I love, and writing more publicly and speaking more publicly and doing what I think we all have as an obligation to share this luxurious position to do something with it. And so that's how I come to be in this position. That's a very long way of saying I'm an academic, but those two things go together. Okay. With all that being said, let me just say a few words, and then I'll try to stand it real quick because we have a lot of discussion to get to. The question is whether or not drug offenders are punished disproportionately. And as Professor Sanders pointed out, I'm actually one of the people who's writing not in retributivist or utilitarian theory, but I spend a lot of my time arguing with folks from both camps. My theory that I'm trying to work out in the book length is a theory about what I call franchise, about the way in which we're fellow citizens, and how that's different than theories that think the point of punishment is either retributivism or utilitarianism. The bonds of our social obligations to each other, right? Our personal obligations are personal, but the bonds of our political obligations is that we're fellow citizens. And that means to me that the same powers that give us the right to punish you when you do something wrong to violate the bonds of our citizenship obligate us to reincorporate you. It's not just that you violated my rights and I punish you and now we're even, right? The very same thing that lets me interfere with your life and throw you in prison because you violated certain bonds are the very same things that mean I have to reincorporate you when you get out. And I think one of the problems we have is that our theories of punishment lack any view that we have to reincorporate returning citizens. So that's what I'm working on more generally. And lastly, on the question of whether or not, on the direct question asked, I'm in some ways a very simple-minded person. So I like to try as best as possible in my field to keep things simple. So here's what's happened. A young person gets addicted to a drug. They now want this drug in ways that are very, very bad for them. They occasionally steal from their mother, let's say, and get in a fight with their mom over money that they stole in their purse. They take the laptop from their friend, and maybe even in some ways they do other things that are problematic. Right? What we have is a social problem, right? So I'm trying to reject the premise of the question, right? When we say are people punished disproportionately, we might think disproportionately to what? Keep in mind, when this thing has happened, there is no yet answer as to whether or not the question on the table is a question of criminal law. Right? Criminal law is an obvious, powerful, and immediately available tool, but it's not at all obvious yet that what we ought to do is punish, much less disproportionate to what. One way we can talk about this is to see the dramatically different ways in which we've treated the opiate addiction epidemic, which is still not being treated well, but is being treated as a social problem in ways that are vastly different than the way in which we attack, for example, the crack epidemic in the 80s and 90s, late 80s, late 90s. Excuse me, early 80s and 80s. It's just to say that when we view lots and lots of problems, there's a real question what we're collectively going to do. And that question, and again, let me just say it simply, it's no different than the question of what are we going to do with a school that's falling apart, or children that have insufficient food, and on and on and on. There are many, many social responses we can have to these kinds of questions. And it turns out, in ways that are heartbreaking, that are applied to those who are the most vulnerable, those who don't look like us, those who grow up in cities that we don't relate to sometimes, and yes, those who have a different, darker skin, is often the knee-jerk reaction. Oh, there's fighting in school, let's send in the police. But if it's our school, where our children go, right? If it's a lovely, I know this area is dotted with gorgeous boarding schools. The response is not, let's send in the police, right? So disproportionate to what already assumes that the only possible reply is that of criminal law, and that's deeply problematic, and I hope we'll get you to speak more about it.
Hi, so for the past 4 years, I've been handling federal advocacy at the Sentencing Project in Washington, D.C. But I grew up in Texas and went to college in a town called Abilene. And if you've ever seen the show Friday Night Lights, then you have a pretty good idea of what it's like there. Incidentally, that's also where I met Jen, my wife of 18 years. That's right, we got married when we were 9 years old. It was in Abilene that I first spent time in prison, not as a prisoner myself, but as part of a prison education program. And I'd like to say it was because of my deep interest in social justice, but really it was out of curiosity. So I'm not sure what I expected, but this prison wasn't like I had seen in the movies. There were no dungeons or cells or anything like that. It was actually very bright and clean. There was very large rooms with bunk beds, dozens of men. And so I'd spend my days sitting at a table bolted to the floor in the middle of this room, and the men would come over and visit with me. Most of them were Black or Latino. And I got to know them, and most of them seemed like pretty regular guys, albeit guys who had made some pretty bad mistakes. And one individual in particular who I got to know was named Jason. He was Latino, a young man, and he was serving a long sentence for armed robbery after a drug deal that had gone bad. And that sounds scary, but as I got to know Jason, I realized that he was really sort of a gentle soul who had gotten caught up in a bad crowd. And he came from a broken family. He had a daughter at home. And he admitted to me that he had messed up. But I couldn't help thinking that if he had had the same advantages and opportunities in life that I had had, that he would probably have been in a different place. And unfortunately, Jason's story is not that unusual. In the United States, there are 2.2 million people in prisons or jails. About 500,000 of those individuals are locked up for a drug offense. In addition, drug abuse accounts for a significant number of people incarcerated for property or violent offenses because of untreated addictions. So compared to 1980, the number of people incarcerated for a drug offense is up 1,200%. So this growth was not caused by changes in crime rates. It was changed by choices we made, namely the war on drugs. Talking about the policy, not the ban. That policy sent more people to prison and kept them there for longer periods of time. So in 1982, President Reagan gave a speech. He had a new initiative to curtail drug abuse, and he compared drug law enforcement to the Battle of Verdun in World War I, which was probably the costliest and deadliest battle in that war. And within a few years, Congress has passed several laws establishing across-the-board mandatory sentencing for drug offenses, providing billions of dollars for drug law enforcement, and establishing a policy to create a drug-free America. Well, needless to say, within a decade, there were few celebrations that we had achieved a drug-free America. Instead, what happened was these mandatory sentencing laws, which were aimed at breaking up drug cartels, largely missed their targets. And instead of kingpins, we ended up locking up in federal prison lower-level actors, so-called mules and couriers, street-level dealers, people like that, many of them struggling with drug abuse problems of their own. These are individuals like Alton Mills, who received a federal life sentence for his role as a low-level courier in drug trade, because he had two previous prior possession offenses. And a woman named Kemba Smith, who received a 25-year federal prison sentence for her participation in her boyfriend's illegal drug activity. Kemba had no prior criminal record, and at the time was 7 months pregnant. Thankfully, both of those individuals have recently received commutations from President Obama, but after spending many, many years in federal prison. And nor has this enforcement of drug law been equitable. As Ekow mentioned, at the federal level, as he alluded to, 3/4 of people incarcerated for drug offenses are Black or Latino. That's even though whites use and sell drugs at roughly the same rates. Perhaps the most dramatic example of this is with crack cocaine policy. In the 1980s, the crack had emerged in some low-income areas, and Congress responded by establishing mandatory minimum penalties for crack. They were much harsher than for powder cocaine. Well, it turns out that 80% of the people locked up for crack since that time have been African American. And if these mandatory penalties worked, if they reduced drug use, if they reduced the harm caused by drugs, you might be able to make an argument that they were justifiable on some level. But the fact is they don't work. According to the National Research Council that studied this, the long prison sentences do not account for a significant portion of the crime reduction. And this is for a couple of main reasons. One, because particularly for drug offenses, lower level dealers are easily replaced. As long as there is a demand for illegal drugs, there will be a ready supply of sellers. And the other main reason is that people age out of crime. So the 18-year-old who is in prison for boosting some drugs from a pharmacy or something like that is much less likely to do that when he's 40. I have some other things to say about what's happening in Congress to try to address these issues, but I'll stop there for now. I did want to say a word about law school. There's a debate about, I'm sure you've been involved with it, maybe with your parents, whether law school is worth the time and especially the money. I think that's debatable, but I think it's the wrong question. I think the question to ask is, what do you want to accomplish with your life? So my first position, it wasn't even a paid job after law school and having passed the bar exam, was sitting in a congressional office on a sofa answering constituent calls, to my parents' chagrin. Eventually I found, a career and a calling in criminal justice reform advocacy. I think I'll probably still be paying off my law school loan in middle age, basically there now. I wouldn't trade my legal education, and I love what it allows me to do.
I'm going to stand up. First of all, Mr. Howe, amazing work. Are any of your students here?
No, they're all in the facility.
Oh, okay, that makes sense. But I really admire what you've done. And I'm so glad to be here. I was getting ready and I went back to my email and pulled up, just searched for Vermont Law School. And I found not only what I was looking for, which was, be sure to be on time and things like that. but I also found the emails I'd written to Vermont Law School over the years. I drove through here a while ago when I was teaching in Texas. And I was just driving through Vermont and I walked in and I talked to some students. And I apparently wrote several emails after that saying, could I come speak? Could I come visit? And here I am, I'm living the dream. And it is a great thing. Professor, I am going to start at the start with a little bit of biography. In 1967, I was 4 years old. And I lived in the city of Detroit on the east side. There was a time when our parents told us we couldn't go outside because the riots were going on. Now, we lived on the east side of the city. Riots were centered on the west side. But the city was occupied not by the National Guard, but the riots were so severe, it was being occupied by the United States Army, by the regular army, people who had gone to Vietnam and come back. And so, kids couldn't go outside. So of course I went outside. And I snuck out and I ran down the block. And there was a Jeep or an armored personnel carrier or something, and soldiers with rifles. And I was terrified. And I ran the other way. And what I remember is my mom running behind me and sweeping me up in her arms, bringing me home. Now that riot, some people would call it a rebellion, was rooted in racism. It had a lot to do with criminal justice. It started because a party for two Black Vietnam veterans was broken up in a way that was too violent, where they arrested everybody indiscriminately. And the riot began as a reaction to that. When I was in law school, I realized the importance
of criminal justice. And I thought the best way for me to be a part of it was to be a prosecutor. So I went back to Detroit, and I was a prosecutor there from 1995 to 2000. When you're a prosecutor in Detroit at that time, you do a lot of crack cases. And that's what I did, among other things. And so the problem that we're discussing, I played a role in causing it. Now, at the time, like a lot of people, I believed that what we were doing was going to solve a problem. That by incapacitating crack dealers, we would solve the very real problem that crack presented in communities both black and white. We were wrong, of course. And I want to talk briefly about things that I hadn't thought through at that time that fits in with what Jeremy just said as well. There's 4 hard facts about narcotics that need to frame any discussion that we have. And the first is that Americans like drugs. That we as a nation are the world's leading consumer of recreational drugs. And even over-the-counter and prescription drugs, we use at a far greater rate in most societies. Things like prescription opiates, I think it's 85% of prescription opiates in the world are sold in the United States. You know, it kind of fits with some other aspects of the American culture. The individualism, we have an attraction to escapism through movies and things like that, and a tolerance for risky behavior. So we have to accept that, at least as our culture exists now, there is an appetite for narcotics. And that leads to the second truth, which is that narcotics are a market that's driven by that demand. That unlike other types of crimes that we prosecute, narcotics are rooted in a market system. They're controlled by the laws of supply and demand. And one of the things that means is that through interdiction and other things on the law enforcement side, the most we can hope for is to raise the price of drugs. That's the most we can hope for, because it's a market. And if we restrict the supply and demand remains constant, then the price will go up. That is our highest ambition in trying to control narcotics. And that leads to the third truth that I want to talk about. And that is that a terrible way to do that is by sweeping out low-wage labor, because it does nothing to affect the market. That when I was a prosecutor, a typical case, and one that specifically I remember, was an 18-year-old. He had 5.3 grams of crack, and he had a gun under a seat cushion in the house where he was selling crack. First offense, he got a 10-year sentence. 5 years for the crack and 5 years stacked for the gun. And there's no parole in the federal system, so he was going to do at least 8.5 years of those 10 years. That didn't affect the market, not a bit. I actually, because it was my case and it went to trial, I drove by the house before the trial just to get an eye on it, and there was someone else selling crack there. It made no difference whatsoever. And so we have to remember that too, that if what we're trying to do is the one thing that we can do, which is raise the price somewhat, at least temporarily, the last way we want to do it is by sweeping up low-wage labor. And then the fourth fact is this, that we have chosen moralism over problem solving. And perhaps I'm characterizing retributivism as moralism, but that's the way it comes across. And I say this as one of the people making those moral statements in court. One of those people that in closing would say, the reason this is wrong is because this person is poisoning his community. That's a very popular prosecutor. You know, of course, we could apply that to people who own fast food joints, casinos, probably the Philadelphia Flyers. But we went awry at a very specific time. And that is, and it relates to crack. You know, crack really drove the higher sentences. And in the 1980s, and there's a few of us here who remember the 1980s, there were two public health crises that happened at the same time. And they were AIDS and crack. And at the start, both were viewed as scourges of communities that were looked down upon. Of course, crack was seen as an African-American problem, and AIDS was primarily seen as afflicting gay men, heroin addicts, and people from Haiti. And that also, all three groups, not favored in society. Now, what happened from there, though, is very telling, because there's a point of differentiation. And it's at a precise time, 1986. In 1986, two things happened. One is that Len Bias died, basketball player from the University of Maryland. And it was thought to be, it was 2 days after he was drafted by the Celtics. For those of you from the Boston area, you know it would be a big deal. 1986, I think they were defending champions of the NBA. They had the second overall pick, and they picked this guy, Len Bias from the University of Maryland, who then died 2 days after the draft. Now, people in Boston were enraged. And that meant that Tip O'Neill and Ted Kennedy were incentivized to do something about crack. Now, they just picked a number at random, and they came up with a 100-to-1 ratio that's been so pernicious, and which I used to support in court. Now, and AIDS went a different direction. And instead of the face being the 6'9" black Len Bias, the face of AIDS became Brian White, a middle school student in Vermont, Indiana. And also, the champion became C. Everett Koop, the Surgeon General of the United States. AIDS went the direction of problem solving. They identified the disease that underlaid it, the structures that created it, and they did something about that. However, and they stepped away from the moralism that had been asking for things like mandatory testing and things like that for people who might suffer from AIDS. And with crack, we haven't yet gotten away from moralism. And the same is true with other drugs. We'll have to wait and see what happens to the reaction with opiates, something that primarily affects whites, or is perceived as affecting whites as opposed to African Americans. There's a lot more to discuss, and everybody else look forward to questions.
There is so much to talk about. We're going to cancel all the other panels and just kidding. So all of you have touched on this a little bit, but Ekow, let me ask you first, and then others please weigh in. The publicly reported face of addiction is of a lighter hue now than it was during the crack epidemic. And it seems that our response is now somehow different. And I know you've commented on PBS NewsHour and other places about that. I wonder if you'd like to elaborate or share your thoughts about that.
Yeah, I mean, so it's not fun to sometimes play against a simplistic person. And frankly, it's not always fun to be the black person saying, well, look, this could be all about race. Then if others were willing to do it, you wouldn't have to do it. Happily on this panel, I'm not. I'll just start where Mark left off, Mark, if I may. Look, we shouldn't be confused as to what's happening, right? So we now have this opiate addiction epidemic, and it's a stunning one. It is one of the things that has contributed to America having, for the first time, a rollback in life expectancy, right? Opiate, and this for the wealthiest country in the world is stunning. By the way, there's a cruel irony that the CDC believes that actually part of the reason we now have this opiate addiction is because doctors overprescribe painkillers. And it turns out that doctors overprescribe painkillers to white people. That is to say, there's this cruel irony that part of what happened is that when doctors see people in pain, they respond differently depending on the race of the person, right? So they do lots of audit studies on this. They give a doctor the exact same treatment, just so you're clear about this. And I think sometimes we find these things so upsetting, we try to find a way to think it can't be so. So they just give doctors the same charts. And they say, how are you going to treat this person? And if the name on top of it signaled white, a doctor was much more willing to prescribe painkillers, whereas if the name signaled black, they were much less willing. And they tried to describe why this might be the case. Anyway, if you generalize this across the country, then it turns out that you're introducing a huge number of people to painkillers, which then years later turns out to, I mean, this is not the only story, this is part of the story. So there's just cruelty on cruelty built into this pain. Then what happens? So, as we said, part of what happens then is how we decide to deal with this socially. Now, I don't want to deny that part of the story is that America has gone through a generation and a half of failed drug use. And so I don't think it's just that Americans said, well, we don't care about black people, we don't care about white people. I think part of it is you see person after person say, we've tried that other one and it failed. But of course, you have to ask why a generation and a half of black souls have to be fed to prisons and halfway houses and then again arrested because and on and on and on. And the answer to that just is, I think Mark's story captures it exactly right. When we see the young AIDS victim was somebody we could think that could be us, then the entire nation mobilized to decide what to do about this problem. Once it wasn't just a gay problem. When you hear story after story, again, I don't want to pretend it's all great out there. I mean, there are lots of heroin addicts being locked up with very treatment. But here's what's true. The presidential candidates, including the Republican presidential candidates, spent time on national television telling us that drug addiction was a public health scourge and sharing stories of sisters and brothers and sons and daughters who had become addicted to heroin. That was not the response in the 90s, right? And it's not the case that in the 90s, people's brothers and sisters were not being addicted to crack. It was that you were ashamed, you hid it. And for those who were there, you remember reading obituaries where people did everything they could to avoid saying what had happened or how they died, right? Because you couldn't admit that your brother or sister had been addicted to the black drug. So there's a deep difference in every level of our humanity, or what we see about our humanity in those who we decide to call criminal. And I'll just wrap up by saying this. Look, I mean, and I'm happy to take questions. There are lots of people who push back on this story. They say, well, look, the violence is different, the addiction is different. All of this I find totally unpersuasive. I should say totally, mostly unpersuasive. I mean, what happened is, during one drug epidemic, we did nothing about it for years and years and years, allowed an underground market that became massive to flourish, cordoned off cities with militarized police. And then we said, man, that's a really violent problem, right? Whereas now, when we see these problems, we start talking, police chiefs start saying, something's changed. I don't know what it is, but we have to see that these are people, right? And so we're starting to intervene at a much earlier stage, not to allow it to metastasize in our cities to become another violent wave of epidemics. And that's entirely about the way in which we view this humanity, whether or not we think these people are returning, right? So I'll just wrap up by saying, you know, we started by this, there's also lots to be said about prosecutors' decisions in charging. And with all due respect, I mean, Mark, your work is incredible. But I think there is a problem with people like us, that we go to law schools and then we focus on what fancy lawyers focus on, which is the federal levels, right? But the action is in the states, right? I mean, the federal prisoners only represent quite a minor number of federal drug prisoners, even a smaller number. The question is, what are police chiefs and DAs doing? They get to make charging decisions about whether or not this counts as a violent crime, whether the fight with your brother over drug money is a violent crime or a social problem. And I think a lot depends on whether or not they think this is somebody worth rescuing, right? Whether or not this is somebody who we want back in our community, right? And I'll just wrap up by just pointing out the obvious connection with common crime. There's no question that somebody who commits a robbery destabilizes and terrifies people. We shouldn't be shy about that. But Robert Milligan robbed millions of people of their life savings. And he now goes to very fancy events in impeccably tailored tuxedos. I assure you, I've seen it. The difference is, no matter how awful what he did was, and it was, the view was always that he was going to be a citizen in return to us. And so there's a whole structure about how to punish him and get him to come back. Right? If the view of somebody who's addicted to heroin is how do we bring this person back to us, you'll have a very different social and institutional criminal law response than a view of it's those people.
Mark, your name was invoked. Yeah, I have to say one thing that I come at this with, and I think I won't speak for Jeremy, but I expect he does as well. And that is from a position of faith. That one of the things that I'm deeply convicted by is the fact that the light of God is equal within everyone. And that's something that has not been recognized by the system. When in your introduction to me, I talked about principles rooted in human dignity. Now, that's not necessarily a religious concept. It crosses all kinds of boundaries. But it's something that's been strikingly missing from our approach to narcotics, that is not seen as who those individuals are. 2 weeks ago, I had a remarkable experience. And that is that I started a clemency clinic at my school. And have tried to work with a lot of other schools to start clemency clinics there. And 3 of my guys got out on the same day, all doing life terms. And I got to call them to be the one to tell them that they were going to get out and get to go home. Now, all of them had earned it. I didn't get it for them. They earned it because they had perfect prison records. They'd done remarkable things in prison. It's credit to them, not to me. But still, I got the bonus of calling them and being the one to tell them that they were going to get out. And it was an unforgettable moment to tell someone that. And that shouldn't have to happen. It should be redemption after someone like Richard Van Lindenau has done 28 years for a relatively small deal. And that's the root of the problem. It's a spiritual failing as much as anything else.
I would add, going to Ekow's points, so the racial dynamics of our response to drugs didn't just start in the 80s either. So if you go back in history, we see a racially disparate response. So in the 1930s, marijuana was seen as a drug that was used, again, by African Americans and Latinos in inner cities. 30 years later came the 1960s, and mostly white, middle-class college students began using marijuana in larger numbers. And public views of marijuana changed almost overnight. Marijuana became celebrated in the popular culture. There were calls for decriminalization. Nothing had changed about the drug itself. What had changed was the perception of who was using that drug. Once we had a different perception about who was using it, attitudes changed dramatically. So I think this tells us something about how we make our policy choices. It calls to question what values and perceptions are behind the public policies that are maybe race neutral on the surface. So 20 years ago, the Sentencing Project put out a report that showed that 1 out of 3 young black men was incarcerated in some way. And President Clinton had a good line, and he said that, what would Americans do if a report came out that said that 1 out of every 3 white boys was in prison? And I think it's pretty clear that there would be a pretty vigorous response from Congress and from the country to that. So I think I agree with what Mark and Ekow said, was that we're really not going to make fundamental change in the system until we see the people who are caught up in the system, like we would see our own families. Kind of a variation on the golden rule. You know, how would we want our families treated? That's how we need to think about the people who are addicted to drugs, incarcerated for drugs. We probably wouldn't call the police and demand a mandatory prison sentence for our brother or sister, son or daughter. So why would we do that for our fellow citizens?
Can I just I just have to, first, I really very much appreciate what both of you said. I just have to say, look, I mean, we also should be clear that in some sense, a lot of this is not about drugs at all. A lot of this is not using policing to control certain communities, right? I mean, Jeremy put it exactly right. So marijuana at first was seen as sort of, in some ways, innocent, and then it became seen as the drug of the Black and actually Latino migrant workers actually were seen as using lots of marijuana. So this was a way of controlling it. I said, look, let's be honest. If what we really cared about was marijuana itself, we would send Trump's deportation teams to invade. We would sweep Madison, Wisconsin. UCLA's campus would be police state. My beloved Michigan, and it is beloved to me. Ann Arbor throws a hash bash every year. And I'm a boring, very conservative person in lots of ways. I'm not pro drugs. I'm just anti-insanity. Right? So if we really care about marijuana, it would be very obvious the kinds of things we would do to try to do that. Now, I suspect we should listen to Mark's wise words. It's very clear that there would be very little we can do to do that, but we know how we would go about attacking. What we care about is policing communities where some people are dealing marijuana. Because wealthy New Yorkers who want marijuana get their drug dealers to come to their apartment and drop it off. And nobody's interested in prosecuting those. And if you try, or frankly, if you prosecuted their children, the kids of Michigan, Wisconsin, Texas, right? Austin, my goodness, Austin, the police state. They would call up their senators. And there's just no question that, as Mark said, our inability to see the common humanity, common equal value of these young people is what's driving our policy.
So let's say we got to that point as a society. Would there still be a role for punishment in our response to drug abuse?
You mean just pure retributive? I would hope not. Or is the model itself fundamentally flawed?
In a society that is so imbued with racism, to have punishment be a function of government is going to reflect that racism. And so I don't think that's the problem with having retributive in its pure form be the motivating factor.
Yeah, I mean, I think it's legitimate for a government to regulate drugs, but the problem is how we take different approaches based on who you are and where you come from. I'm not sure that, I agree that the society is imbued with racism, and I'm not sure that we can do that effectively.
Yeah, so, and now I'm going to say very simple, unfortunately flattering things, but unfortunately not true things. So I actually don't know how I would answer a drug problem as such. I don't know what we should do about them, especially the most destructive, addictive of drugs. I also think there's a big difference in where you are. I think there's a rightful difference in societies that are facing the production of drugs, who have a real shot at keeping it out. I mean, it's not surprising that if you travel internationally and have these discussions, some countries actually are much earlier and thus take much more draconian measures to stop drugs from coming into their society. And while I find those measures stunning, I don't find their position insane because they don't want to be America, right? But I think once you're American, I mean, this is just a simple way of saying there's a difference when you have the first instance of a transmutable disease than when it's a widespread problem. And I think, but my simple answer is if we want to know how we would treat things, if we care about the people they affected, we should look at what we do when it affects my people. Which is a simplistic and stupid way of saying it, except it's true. So if you ask me what would we do, I said, well, let's look at what's happening when, for example, the opium crisis has hit white and rural America. And it turns out we've marshaled huge amounts of resources to start thinking about it as a public health problem. I don't even know if that's the right thing to do, but I suspect it gives us a real world test of what we would do if we cared about the person's effect. I don't think we have to imagine it any longer.
So let me pick up on that. Mark, you are in charge of the universe, or at least a place, and you get to design from scratch, free of the baggage that the three of you have discussed, drug policy for this country or for a place. How does it look differently than our current approach?
Yeah, well, I mean, assuming that place I get to be in charge of looks like America, and we do have that demand for narcotics. One thing is that narcotics are properly regulated. I mean, that you have some things that you have a prescription for. If you don't have a prescription, you're not allowed to buy it, and it's illegal for you to have it. That makes sense to me, that there should be some drugs that are regulated that way. I don't think you just throw open the doors of the pharmacies and let you go in and buy whatever you want, or on the street for that. But in terms of how to do the one thing we can do through interdiction, which is raise the price somewhat, first of all, I think that's worthwhile. I mean, I know it sounds diminutive that all we can do is raise the price a little temporarily, but we do know that raising the price does reduce use of even very addictive substances. We know that from our experience with cigarettes. Once we raised the taxes on it, smoking rates went down. So it is worthwhile to try, now that the resources we put into it, the way we've been doing it. What I would do is based on experience I had in Texas. So I'm teaching at Baylor, and the Republican Club of Dallas invited me to come up and speak to them. It's right after Spears came up about narcotics policy. And it's pretty much what you'd expect of a Republican club in Dallas. And I was going along and kind of explaining what I did as a prosecutor, and this guy stands up, and this is not, the Q&A, this is in the and he says, son, I'm not going to do the whole accent, but Jeremy probably could. But he said, you're never going to down a business by, arresting the greeter at Walmart. And what I'm saying, a lot of it comes from that one comment from that guy. And so I figured this is a great opportunity. I mean, they're Republicans, they're in Dallas, they're business people for the most part. You shut down the business. And they all said the same thing. Every business audience I've talked to since then says the same thing. Cash flow and credit. And so if we want to raise the price by disrupting businesses, we don't arrest the people. And we don't do these piddling little forfeitures where you take someone's car. You identify the cash flow going back to the source, because they don't have access to the traditional credit. And you grab the money. If it's bulk cash going back to Mexico, you use the incredible surveillance abilities we have, and you find it, and you take it, and you keep it. I mean, you're not arresting the guy back in Minneapolis selling cocaine. He just doesn't have a job anymore, at least for a little while. And we have that ability. And one thing that has enhanced it is the FBI has gotten very good at seizing and identifying and seizing materials for terrorism, which often has very complicated routes back. We know how to get it. So we have that ability. That's what I would do to try to disrupt drug markets for a bit.
Jeremy, you're in charge.
Fix it. So going back to a sort of sweeping statement I said earlier about basically the country being racist, I just wanted to give a little bit of factual support for that. So in the criminal justice system, people of color, African Americans in particular, are much more likely to be arrested than whites after the same offenses. When they are prosecuted in federal courts, they're more likely to be charged with penalties that carry mandatory sentencing. Even when they've committed the same offense, African Americans are more likely to get longer sentences than whites. And so really you see throughout the criminal justice system this sort of racial bias. So in that system, in the federal system, and I agree with Ekow that a lot of the action, most of the action is at the state level, but we need to eliminate or at least reduce these mandatory penalties that take discretion away from judges. I don't think it's going to solve all the racial disparities, but allowing judges a safety valve, more flexibility in sentencing, I think is one way to ensure that we don't see some of the harshest outcomes along prison sentences for drugs.
So, I mean, I think one of the things about studying law is you start to realize how so many things are, right? So when things are reported in the media, you hear, well, this person's charged with a violent crime, this person was not, that's part of it. Once you actually get into the guts of it, you realize it's not clearly that simple, right? So let's take an ordinary case, purse snatch, right? So if I steal Professor Sand's wallet, it can be charged as a larceny, petty that. That's quite minor way. It's not trivial. And I'll get some punishments and maybe some convictions. But there you have it. If, however, he reports that I use force, then it'll be a robbery. That's a very different deal. That's a felony. And that might just turn on whether or not the prosecutor decides that I tugged. I mean, really, it's that, you know. So, and the prosecutor will keep asking people, did he tug Henry Walker? And, you know, if the prosecutor wants eventually, the professor will say, yeah, I guess there was a tug there, right? So there are all these subtle ways in which a system that's driven by prosecutors who are happy to keep locking people up. The next, you know, so as a way to become the supervising prosecutor, as a way to then become the DA, and then run for governor, right? There's an old joke that people think the problem with every DA is that they want to be governor. It's not true. The problem with every DA is that they want to be president. So, you know, a lot of it is about how we make every little decision, how we decide just on the whole to tackle the problem. I just want to disagree with Mark in one way. It's not actually a disagreement. I think what he said is largely right, but only as these things are never completely right. So the thing is, there's actually been very interesting controversy about cigarettes and price raises, as you well know. And it turns out that when you have a big jump in cigarette prices, you get depressed use, but only for a short time. And then it goes, you know, people will say, I'm not paying an extra $1. Then a week later, they go, I'm paying an extra $1. So it turns out that the drop of cigarette use is a deeply complicated story, in particular about an entire country that dedicated itself for a generation to tell people not to smoke cigarettes, right? In millions of different ways, as everybody here knows. In a deep concerted social effort, the same as our reduction in drunk driving, right? These are deep commitments that an entire society has to make. My only point is, look, if we're going to fix this problem, we have to do the same thing, right? You have to dedicate yourself as a society in a 360 way to solving the problem. The problem is when these problems affect communities we don't care enough about, we say, that's too hard, right? When it's cigarette smoking, we say, we have to do this, right? When it's drunk driving, we say, we can't lose another child. And so a lot of it depends on not just our elected officials, but how much we're all willing to give, how much we, Mark, you said in religious terms, which I share, but I need not share. How much we're going to see these people as one of us, how much we're going to care as a society.
Shall we be brave and take some questions from the audience? I think there's some handheld microphones, so if you would wait until the microphone is present.
Thanks for the discussion so far. My name is Elijah Hawks. I'm co-principal at Randolph Union and a co-teacher of a class. We've got our class here today. It's a high school just up the road. I'm wondering if you could talk, we've heard a bit about supply and demand in the market for drugs. I'm wondering if you could talk about supply and demand in the market for inmates and the privatization of prisons and how that connects to the conversation so far.
So the Sentencing Project has done some work on privatization of prisons. So it's often the first question that we get in forums like this. I think that you know, it's a stain on our democracy, the fact that we have private prisons, that we incarcerate for profit. I think it would be a mistake to focus too much on it, because I don't think that private prisons are the reasons why we have why lawmakers took a tough on crime approach throughout the 80s and 90s. I think it had much more to do with race and political gain. But I think that, you know, there's certainly evidence that there are abuses in private prisons. There's a lack of oversight. There's not services that we expect people to get when they're incarcerated. So it's a reason for concern, but we think shouldn't be the focus of criminal justice reform.
Can I just add that I also think it's a slight mistake to focus on private prisons, right? Because one of the things that's happened as we develop our prison system is that we ship prisoners very far away, disconnected from their homes, disconnected from their families, to small towns where the prison, whether it's private or public, is the economic resource. And so you have the same economic dynamics of a prison town that needs the prison to stay full, regardless of whether it's private or public.
I was wondering what you thought the prospects were for federal legislation that would address some of these problems, and which problems you thought were the most important for federal legislation to address.
So the good news, there's been a lot of pessimism, but the good news is that policymakers, at least in Washington and in a number of states, have begun to recognize some of these problems. In criminal justice reform, now is one of the few issues where there seems to be common ground for the parties to work together. In fact, in Washington now, groups like the ACLU, Sentencing Project, civil rights groups are working with the Koch brothers, the Heritage Foundation, other conservative organizations to try to advance criminal justice reform. Of course, the devil is in the details, but I think that the most important thing at the federal level is to really change these mandatory sentencing laws, particularly for drug offenses, and that's where the legislation has been focused. On the back end, allowing shorter sentences for people who participate in federal prisons and rehabilitative programming, and such as job training, drug treatment, things like that. The question, I think, is whether this sort of bipartisan momentum can be sustained. So we've been in a period of historic lows in crime rates, and we're seeing an uptick in homicide in some major cities. A group of mostly white Southern senators is circulating a Willie Horton style ad. I guess you all know who Willie Horton was, but it was a famous ad in the campaign in the George Bush and Dukakis campaign, featuring an African-American man who became sort of the face of soft on crime, and that's sort of happening again, and the purpose is to kill the sort of sentencing reform bill. And even though the response to heroin has largely been a public health focus, there have been some efforts here and there to sort of get tough on heroin, offer mandatory minimum amendments to increase prison terms for that. And I think there's always a danger of the sort of bad old days of tough on crime coming back. So for those reasons, I think it's important. Some activists say, the bills don't go far enough. We need to hold out for more reform. I think we need to sort of seize this opportunity, make some progress where we can. I think then we can consolidate those gains and move on to the next fight from a stronger position. Whether or not the bill can pass this year, it's looking sort of unlikely. We're 2 months before a presidential election. I know Secretary Clinton has promised to make this a priority in her administration, her opponent not so much. So I think that remains to be seen.
Hi, thanks for coming today. It's been very interesting so far. It seems like some of the conversation has been about moving away from punishment. And I'm wondering if you guys have opinions about sort of flipping this dialogue and instead of criminalizing, decriminalizing, legalizing certain drugs and regulating, talk about it's a public health crisis. There have been certain states, obviously, that have taken this approach with marijuana. I'm wondering if, on a broad, general level, you guys have opinions about legalizing and regulating drugs.
Well, I'll go first because my answer is short. That in terms of full legalization, I'm in favor of that for marijuana. I think the social costs are relatively low, but not for other drugs. I do think that legalizing marijuana will go towards solving some of these other problems as well. For example, when legal marijuana is available, we see lower rates of opiate addiction.
We don't take a position on legalization, so I would defer to Mark.
I think these are just incredibly difficult questions, and if I had an answer, I wouldn't have kept it this long, really. But I will say, from a personal point of view, philosophical pieces on this, and my rough answer is something like, I do think it's not surprising that philosophical theories converge around prohibiting addictive drugs. Because there is something I think that we all see in the way human agency is destroyed when something is addictive. But really hard, heroin strikes me as destructive. Notice though that doesn't tell me that the answer to how to deal with heroin is legalization, right? And so I have the odd position of being quite conservative, as I've said in many of my personal decisions, right? For example, in Amsterdam for stretches of my life, and it's not as though I rush to recommend the Dutch model at all, but it's obvious to me that society has to grapple in much more thoughtful ways than our knee-jerk reaction that criminalization is the answer to. Part of this is maybe by reminding us that the big problem here is that we are the wealthiest country in the world and we want to buy this stuff.
One more question, and I think we'll have to wrap it up.
Hi, I was wondering, recently Sandra Bland's mother received a settlement that included more oversight within the prison. And I've been reading a lot about prisons that temperature control, for example, where prisons are extremely hot or freezing cold, and it amounts to some type of cruel and unusual punishment. And I was wondering if you could talk about, it might amount to that. I was wondering if you could talk about just generally how terrible prisons are and whether people are aware of this, and how, practically speaking, we're not going to get away from putting people in prison, I don't think, anytime soon. So what can we do to put in practical oversights to prevent terrible things from continuing to happen?
Briefly, gentlemen. Yeah, I mean, there's some jurisdictions are much better than others. I've visited a lot of prisons. Jeremy's probably visited more, and they vary so much. I mean, in Minnesota, we have some actually very well-run prisons where there is rehabilitation that actually occurs. I was recently at the federal prison in Vermont. It's a terrible prison. And talking to the people there, you can see the destructive force it is in their lives. So we have to take the best practices from the best ones, have the other jurisdictions be willing to spend the money to improve.
Yeah, I think it's a question of political will and funding. Everyone agrees that if people are going to be incarcerated and they're getting out one day, we should make sure that they can be productive citizens when they get out. But what does that mean? That means getting them an education. It means training them to do a job while they're incarcerated, making sure that they get drug treatment. And we don't even provide those services for people outside of prisons. So it's going to take a larger commitment politically and from all of us as well.
I mean, what is true is that the worst of our prisons are really horrific places. I mean, so our jurisprudence has developed to say something roughly along the lines of, if the prison warden didn't order it, it doesn't count as punishment. So we sentence people to be raped. We shouldn't mince words about it. We sentence people to things that would be a violation of the 8th Amendment because we know with certainty that this will happen to them when they're there. And I know we keep repeating the same thing, but it really is a case of, if we saw these as people coming back to us, it would be unimaginable that the worst of our prisons. I'll finish this by saying, it is a stunning feature that the largest state in our union has declared their prison conditions unconstitutional. Right? California declared their prison conditions unconstitutional because they're so overcrowded, so horrific, such lack of services, such economic violence.
Final question, comment?
Thank you all for sharing a bit about your personal stories, graduating from law school and then moving into the real world afterwards. One thing that you have a bunch of potential future criminal attorneys here, whether that's defense or deputy prosecutors, on an individual level, folks starting out at the beginning of their careers, what would you recommend them to do to start tackling some of the pieces of the problem you've highlighted today? Thank you.
Well, the most important thing is to work at retail. And I mean, we do wholesale work, policy work, but the retail side of going into a prison and meeting someone. The other thing is this, I know this is a school that's full of advocates. And I want to say something about that. One thing I didn't explain was how I went from being that prosecutor to being the person that pursued the other side.
And here's what happened. I went into those sentencings, and there was often federal defenders on the other side. And in Detroit, particularly, there were two, Richard Helfrich and Henry Seymour. And I would, you know, it was a mandatory case. I didn't even bring the file over. And I remember once the judge saying to Dan Simo, "Are you going to make your usual futile speech?" And he went on for 20 or 25 minutes about what this was going to do to that young man, what it was doing to his community, the African American community in the city. You know, how this wasn't solving the problem. And eventually, it worked on me. None of those people got a lesser sentence. They were mandatory. So anyways, after Spears came down, I got calls from a bunch of judges, because it gave judges more discretion. They were very happy about this. And one was from a judge named Art Turner in Detroit. And he said, "What happened to you? You were a hard ass." And I told him the story I just told you about the futile speeches. And he said, "Did you ever tell Andrew that?" And I never had. You know, so I called him up. But here's the thing, is that if you're an advocate, whether it's for this, the environment, whatever, it may feel like you're making futile speeches, but you don't know who's listening or how it's going to impact them. Don't go home thinking no one heard you. Andrew Simo didn't go home thinking, "Well, I changed the prosecutor's mind," but he did. They won't tell you, and you won't see the effects that you have. The lives or the rivers, I mean, whatever it is you're out to save. But give those futile speeches, and might as well start now.
I can't improve on that, but I'll just mention an example. My boss, Mark Bauer, who's been working on these issues for almost 40 years. And if you look at we have this graph on our website that shows that during this time, the incarceration has just skyrocketed the entire time. But I think finally in recent years, there's starting to be a change in the way in attitudes about these issues. So just to Mark's point, you know, keep the faith, and you know, don't lose heart as you see failure, because you have to have faith that your work will, that the seed you sow will pay off in the end.
Final words.
Well, now I'm 2 strikes down.
It's tough.
It is hard for me to improve on that. Look, I do try to tell my students that we have a role to play, and it's actually, and a couple of people have said, I will be paying my student loans, presumably just before I die. But if I had it to do over again, I'd go to law school 5 times again. I wake up every day thinking I'm blessed to have this kind of role. One of the cases my law firm represented was a Bush v. Gore, most famously representing Al Gore for the Supreme Court. And I always take such great part in that in America, when the president is up, the presidency is up to the controversy. We don't call the army, we call it lawyers. That's a noble thing. And I know our election's been going on for 1,000 years, but we should remember, you know, Franklin said it's a republic if you can keep it. We have a really wonderful job to do that. I'll just say this, look, I tell my students, you can do more good as a great prosecutor in 1 day than you can as a zealous defender in a month. That's not always true though, because part of it is, and so here I'll part a little bit from mine, part of it's fighting both retail and upstream, because I have lots of students who go to the prosecution and leave quickly. They're exhausted being the only person in the office. So it means a DA who's going to change the culture of their office. And lastly, it means for us, we have to take our case to the people. I think sometimes we lose heart of that. It's very easy to play old politics. I locked up a bunch of people, the crime rates fell. And it's not that some lawyer stands up and says, the crime rates were the exact same 2 years ago. You locked up a bunch of people because it's an election year. This is nonsense. And take heart that if you make that message elegantly, you can be elected DA, not just do the same boring thing that you know deeply is unjust. Mark looked and said, this isn't right. You changed it. We are citizens, and we can take our message to our fellow citizens and have faith that there really are better angels in us.
so much more to talk about, and yet somehow I feel like our work is done. So let's thank our three panelists. And start back promptly with 15.
What's up next?
I'm so happy we're speaking.
Great.
Okay, guys, I'm glad you enjoyed your break. Let's kind of come back in and get ready for the second panel. So the next question we're going to focus on, or as we saw with Professor Yankah, maybe challenge the question, I'm good with that, is does criminal law go easy on white collar crime?
As with the last panel, we have an amazing lineup now. And we're going to have them speak in the order I'm introducing them in. The first person on my left is Jesse Eisinger. You may notice that he's also our keynote speaker at lunch today, but he won't be repeating his remarks, so please stay for lunch too. But if he does, I will interrupt him, you know me. Okay, Jesse is a senior reporter at ProPublica. In April 2011, he won a Pulitzer Prize for national reporting for a series of stories on questionable Wall Street practices that helped make the financial crisis the worst since the Great Depression. He also won the 2015 Gerald Loeb Award for commentary. He's also twice been a finalist for the Goldsmith Prize for investigative reporting. Eisinger was a regular columnist for the New York Times Dealbook section. His work has also appeared in the Times, the Atlantic, the New Yorker, the Washington Post, the Battler, I'm not sure what that is, the American Prospect, and on NPR and This American Life. Before joining ProPublica, he was a Wall Street editor of Condé Nast Portfolio and a columnist for the Wall Street Journal covering markets and finance. Sept to Jesse's left is Professor Peter Henning. After graduating from Georgetown Law Center, he had several jobs and then was until 1991 a senior attorney in the Division of Enforcement at the SEC, where he worked on cases involving insider trading, penny stock fraud, market manipulation, and accounting irregularities. From there, he moved to the criminal division of the U.S. Department of Justice, where he worked in the fraud section on the investigation and prosecution of bank fraud. During this time, he also published articles in the Kansas Law Review, the St. Louis University Law Journal, and the American Criminal Law Review. In 2013, he was a Fulbright Scholar teaching in Croatia. He's received a number of teaching awards, including the President's Award for Excellence in Teaching and the Donald H. Gordon Award for Excellence in Teaching. His scholarship focuses primarily on white-collar crime, constitutional criminal procedure, and attorney ethics. In addition to numerous publications in law journals, he's also a co-author of 3 case books on white-collar crime, criminal law, and criminal pretrial advocacy. He writes a regular column, which you may have read, called White Collar Watch for the New York Times Dealbook, and has been quoted in a number of media outlets. And then to Professor Henning's left is Professor Ellen Podgor. She is a former deputy prosecutor and criminal defense attorney. She teaches in the areas of white-collar crime, criminal law, and international criminal law. She is the co-author of numerous books, including White-Collar Crime in a Nutshell, Understanding International Criminal Law, Mastering Criminal Law, etc. She's authored more than 70 law review articles and essays in the area of computer crime, international criminal law, lawyers' ethics, criminal discovery, prosecutorial discretion, corporate criminality, and other white-collar crime topics. Like our other panelists, she's been interviewed by various media, including National Public Radio, newspapers across the country, including the Times, the Journal, Post, the LA Times, the National Law Journal, the Tribune, and Business Week. She's also the editor of the highly ranked white-collar crime professor for Crime Law, and she is the chair of the advisory committee of the NACDL, White-Collar Criminal Defense College of Stetson. She received the Robert C. Heaney Award in 2010, which is the highest honor given by the NACDL, which is the National Association of Criminal Defense Lawyers. She is also the recipient of the Dickinson Brown Award for Excellence in Faculty Scholarship, and so on. So we have literally an award-winning panel, amazing folks, and we will begin with Jesse Eisinger. Welcome you all. Let's welcome to Columnist.
Thank you so much, Jen, for that introduction, and thank you for the invitation. I'm really flattered to be here. And so, you know, I thought from the earlier panel's cue that we should start with something biographical, as I was trying to think of what I would say, but I don't have a life of white-collar crime to account. So, so I figure maybe I should just move on to clear up any questions that people have about the title of my book, which Jen referred to earlier. So here's the story. In early 2002, Jim Comey became the U.S. Attorney for the Southern District of Manhattan. You know him now, or many of you know now as the FBI Director. And he was replacing Mary Jo White, who now, of course, is chair of the SEC, but was a long-time U.S. Attorney in the Southern District. Southern District is the best prosecutorial office in the land. If you are confused about that, or you have any questions about that, you just have to ask the alum of the Southern District. They will clear that up for you later. Excellent. And they're best known for securities law enforcement. So this is the heart of really corporate white-collar criminal enforcement in this country. And Comey comes in, and Mary Jo Whitehead is a beloved prosecutor. And the prosecutors have just loved her. She's really loyal to her charges, defended them, fended off a lot of turf battles within the Department of Justice, which is this kind of strange, sprawling bureaucracy. And so Comey does an interesting thing. He really kind of lies low for a long time and doesn't make a big splash. He's kind of known for liking to give speeches, but doesn't do anything like this for many months. Then a couple of months into it, he finally decides to go to the criminal division's monthly meeting. And they all gather in the courthouse. And at this meeting, you read off the box score. The box score is what the trials were in the last month and what the result of the trial was. And it's a kind of ritual. And the guy is about to give the box score, and Jim Comey says, "But I just want to say a few words." And these are really his first words to the whole group of criminal prosecutors. And so he says, "Well, I just have a question. How many of you have never lost a case?" And these guys, you have to understand who the Southern District prosecutors are. Most of them are really young go-getters, ambitious. They have gone to the best high schools and the best colleges and the best law schools. And they're going to become future U.S. attorneys and future, maybe even directors of the FBI, cabinet secretaries. These are the most, the elite of the elite, and they're go-getters. And they, so a bunch of hands shoot up. They really never lost a case. He said, Comey looks around the room and he says, "Well, me and my friends have a name for you guys, the Chicken Shake Club." Hands go down. There's some nervous laughter. And Comey goes on to explain what he means. And he means that your job is not to win cases. You're not there to rack up numbers. What you're there to do is prosecute righteous cases. And you want to take on the most ambitious cases you can. And you want to do the right thing. And you want to not be concerned with just winning, because that will lead you to taking on the easy targets and doing not what's right, but what's expedient. And so it's a very important lesson for all these young prosecutors who are concerned with winning and racking up a good record. But what happens over the next decade and a half is that the Department of Justice, and this is sort of my argument in my book, with coming from Simon & Schuster, and I tell everybody on that, is that the department becomes the Chicken Shake Club for corporate white-collar crime. What I mean by that is they no longer have the will and ability to prosecute top corporate executives at the highest echelons of corporate America for the biggest companies. So yes, they still do some prosecution of corporate white-collar crime. Sometimes they prosecute individuals, although we see that a lot less. But what they don't manage to be able to do is hold CEOs, CFOs, chairmen and chairwomen of the board accountable for corporate crime. I'll give you a few statistics and then I'll wind up because I think we can, it'll be interesting to kind of debate the reasons why this has come about. But so the journal, Wall Street Journal, did an analysis of the 156 criminal and civil cases brought by the Justice Department and the SEC and the CFTC against the biggest banks since 2009. 81%, the government didn't even charge or identify any individuals. In the remainder, they charged 47 mid and low-level people. Only one was a boardroom executive who was charged civilly, not criminally. So they're just not doing this. They're not focused on individuals, and they're certainly not focused on high-level individuals. And part of this is that white-collar crime enforcement has just dropped off at the Department of Justice. Not it's faded as a priority. In the 4 years between 1992 and 1995, 19%, or 1 in 5 cases were white-collar cases. And there's a lot of fiddling with the numbers and categorizations. So it's not a pure way to look at this, but it gives you a general rubric. 2012 to 2015, that number had fallen to under 10%, 9.9%. And they're winning more cases. Prosecutors win most of their cases. They settle most of their cases, and then when they take cases to trial, they win most of their cases, federal prosecutors. But in the earlier period, 92 to 95, they won at an 87% rate, and then recently they've dropped this number and they're winning at a 91% rate. So they're taking many fewer cases and they're taking easier cases. And therefore they're racking up the wins. They're going to be the lowest in 2015, according to Syracuse University, it will be the lowest number of white-collar cases in 20 years. So even though the economy has grown so much in that period, corporations and publicly traded companies have grown so much in that period, the number of cases is down, corporate convictions is down almost 30% from 2004 to 2014. So what we have is a lack of priority for this kind of crime and a lack of ability to focus on the individuals. And the last point I'll make in these introductory remarks is we heard a lot about the point of criminal enforcement in the first panel. I argue that in the white-collar arena, deterrence works. It's much less likely, in my view, to work in the criminal setting when people are poor, when they're addicted to drugs, when they have much lower stakes in society. But what you're talking about when you're prosecuting corporate executives is people have a lot of stake in society. They have assets, they have roots in the communities, they have reputations to protect, and they're very well informed. So they read the media and can see what's happening with their peers. So one good prosecution does a lot of good for society because it sends a message. So, what we're doing in our society, as we heard in the first panel, is locking up a lot of poor people, disproportionately people of color. And my argument is we're not locking up enough of rich white people, mostly men, who are very powerful.
I'm going to stand up just because I feel like I'm on Jeopardy. And I'm just worried I'm going to have to buzz in. And certainly for those of you up in the cheap seats, this is a great room. You got to get on StubHub earlier. Let me, just a little bit of background. One of the questions Jennifer asked us to talk about a little bit was, how did we get here to where
each of us is in our career, and I attribute it to blind dumb luck. So that, you know, if you are a high school student, you know, when I was in high school, I wanted to be a lawyer. Then I wanted to be a philosopher. Then I wanted to be a teacher. Then I wanted to be a lawyer again. Did I have any clue? I went to law school and thought, God, common law is the greatest thing. I can't wait to take common law, and then I took it. And it just, and then I was like, I gotta take a business class. My brother was in law school, and as older brothers do, he said, don't be an idiot. Which I always thought, you know, boy, that's great advice. I'm gonna go be an idiot. But he goes, look, you gotta take corporations because business is important. And I took corporations, and I loved it. And I was like, this is the greatest thing on earth. And then I took securities, and I started doing more and more stuff. And then I got lucky enough to get a job with a judge. And then I had to look for a job. I met my future wife. She was moving to DC, so the extent of the planning was, all right, I'll move to DC. And I interviewed at the SEC. I didn't find out until 2 years later, the judge I worked for got me the job. Because he called a friend of his who was a judge in DC who had been head of the enforcement division and said, hire this guy at the SEC. And he called his people. 2 years later, I thought I aced the interview. I stink at interviews because I'm shy, even though it doesn't appear that way. But my own merit, I didn't, but that's fine. Did I have a plan? No. And then I went to the Justice Department because, as Bill Black is going to talk about, I think, the banking system nearly collapsed. And thank God we solved all the problems back in the early 1990s. No bank would ever, again, be stupid enough to write a loan where people don't provide evidence of their income. Right? You're never going to give a liar loan again. You're never. So then I got into academia. Why? Right place, right time. I applied when the school that I'm at now, Maine State in Detroit, needed somebody who could teach corporate law and criminal law. There weren't a lot of us, and I was the last one left standing. So I got the job that way, and then got into this little niche area that I thought was pretty interesting called white collar crime. And so I wrote a short article that went into the Champion. It's the monthly magazine of the NACBL. And after I wrote it, I got an email from this person named Ellen Podgor. And I remember I went home and I said to my wife, I got a really nice email from the most important white collar person in the United States. I was so excited, and I printed it out and I said, Ellen, as I pronounced her name then, Podgor, Ellen Podgor liked my article. You don't know where you're going to end up. After I wrote that article, I was on the hiring committee at my school, and we looked at a candidate who we hired named Eisinger. Jesse's mom. You don't know what's going to happen in your life. So if you are sitting there fretting, going, I don't know what I want to practice. Great. Find something. You'll end up somewhere. I ended up in white collar crime, and it has been a fascinating area because it has changed. In the mid-90s, there may be a dozen of us, 15. I remember I proposed a white collar crime course, and I looked around in different law schools, and I saw there were about a dozen law schools that offered the class. Now, there are a dozen case books on white collar crime, including one that will be revised by a member of your faculty here. So, this has become an area. Did it get covered by the Wall Street Journal? Yes, it did. But it was not the kind of front page headlines. In fact, the front page headline made by the Wall Street Journal was when one of its reporters traded on information that was going to be in his column. So he, in fact, engaged in insider trading. And so it was a backwater area, and now...
None of the present panel.
No. Jesse's predecessor writing I thought it was head of the tape, right? Heard on the
Heard on the street, heard on the street. He was ahead of the tape. He was the tape guy. His mother was very proud of him. I know more about Jesse, including his early childhood, which every proud mother will always share. Jesse.
All right, back to our.
Disagree on the deterrence point. That'll come up later. So what do you have now? You have a Department of Justice that is claiming to focus on white-collar crime. In fact, you have a memo that came out last year from the Deputy Attorney General, Sally Yates. Whenever you become Deputy Attorney General, you put out a memo that gets your name attached to it. So there was even a Holder memo at one point in time, and then a Thompson memo. And then, the names just go on and on. So there's a Yates memo that came out. And the Yates memo, in response to the criticism that Jesse made, which was, where were the prosecutions of individuals from the financial crisis? We saw plenty of companies get deferred prosecution agreements, civil settlements, but where were the prosecutions of the corporate executives or even individuals within the banks? And so in response to that, the department's, the Yates memo's policy is, if a corporation wants credit for cooperation, in other words, you can get one of these deferred prosecution agreements, non-prosecution agreements, whatever it happens to be, that if you want that credit, any credit, they even underlined any, that you have to identify individuals who were involved. Okay, great. Now we're going to get a bunch of cases against individuals. Are we going to get more cases against individuals after the Yates memo? I'll give you the short answer, and then of course, no short answer ever suffices. No, we're not. Here's one reason. There are a bunch of reasons, but here's one reason. And one reason is that the courts have actually become more hostile to aggressive prosecutions of individuals in white-collar areas, especially in fraud areas. And I can give you one example. I don't want to go on and on, but one example is a case in the Seventh Circuit called United States versus Weimer. And Mr. Weimer was an executive at a bank, and the bank got caught up in the financial crisis. And so capital was very low. It took bailout money and desperately wanted to pay off the bailout money so it could pay its CEO more money. And so it had to sell a development that it owned a share of in Texas. And so Mr. Weimer was an executive at the bank and was assigned to negotiate the sale. So he negotiated with a couple parties, and he saw that one was a front runner. And so he told the owners of the front runner, he goes, look, the bank wants me to get a stake in the deal. I need to have an equity position in it. Otherwise, they're worried that they're not going to get paid off. And so the executives go, fine, we'll give you 5%. You can make a small investment. All right. Then he goes to the bank and he says, I think we can do a good deal. Those guys want me to have 5%. That I've got to get 5% of the deal. Otherwise, by the way, guess who he was lying to? Both sides. He came up with this himself. Is that a scheme to defraud? The jury said yes. The Seventh Circuit said no, it is not. Why? Because lying during negotiations is immaterial. Whenever you negotiate a deal, do you expect the other side to actually tell you the truth? This is my last best price. Do you actually believe that? Go to a used car lot. It was driven by a grandmother. You don't actually believe what you're going to a used car lot. What the Seventh Circuit said was, hey, you can lie. So are we going to see more? Well, I'll give you a counterfactual. This past week, we saw an engineer from Volkswagen charged with a crime related to the defeat device. Oh, okay. Oh boy, the Justice Department's done it. They got one guy. Are we going to see more? I think the courts are suspicious of aggressive prosecutions. And so when Jesse pointed out that we had very few prosecutions of executives, One reason may well be that the courts are suspicious when prosecutors take on these cases that involve an aggressive theory of fraud. And so, are we going to see more prosecutions? I think the answer is no. At least I don't think we'll see an uptick in that. The question I don't have an answer to, and that I leave up to you, is whether that's a good thing or not. Because do we want more people pulled into court who might be better regulated by civil means? I don't know the answer to that.
I loved Peter's first article.
Everything after that.
I always hate speaking after Peter. He's so good. But we don't always agree on it. And first of all, I'd like to thank the Law Review, the professors. I mean, this is a great place, and I am so impressed with the students here. You just have done a spectacular job of everything creating this symposium, and it's really an honor to be a part of this. So thank you very, very much. Before I talk about myself, I want to talk about two other people. I'd like to tell you the story of two men, Abner and John. And I do it with a certain trepidation, because I'm here at a school that's nationally and internationally known for being the environmental law place. And both of these cases were environmental cases. Abner was in the seafood business. He was a middleman. He would get the seafood from others, and then he would sell it to consumers. He was a quiet, he was a law-abiding man. He was a family man. He had never been in trouble with the law before. He had a wife and 3 children. He worked very, very hard to put food on the table. And he was a good husband. He was not a rich man. Abner agreed to buy some Honduran spiny lobsters from a man named David. He'd done business with David before, and there weren't any problems. But then one day, the lobsters did not arrive. And he was very concerned. He had customers out there. And he knew he had to get to the customers the lobsters. Little did he know, he was about to be charged with felony conspiracy charges. It seems the lobsters that David was shipping from Honduras were being sent in clear plastic bags. You heard me right, clear plastic bags. Abner was charged with a violation of the Lacey Act, a violation that he was alleged to have been shipping lobsters in clear plastic bags, which was supposedly against Honduran law. And the United States was going to prosecute him for violating these spiny lobsters in clear plastic bags against Honduran law. Not US law, other than through the Lacey Act, but Honduran law. The government brought into trial an agency person from Honduras to say that Abner had violated 3 Honduran laws, including transporting spiny lobsters in clear plastic bags instead of cardboard boxes, that some of the lobsters were smaller than the legal limits in Honduras, not in the United States, and that a Honduran administrative agency prohibited the harvesting and sale of egg-bearing lobsters. Abner was offered a plea agreement, and he said no. He said, I had to prove to my country and those who mattered to me the most that I was the same law-abiding and honest citizen I had been throughout the first 54 years of my life. Abner went to trial. Abner was convicted of violating the administrative regulations, and he was sentenced to 97 months in prison. That's over 8 years. He served for 6 years in prison, and he served 3 years supervised release. He was given a fine of $15,000 and a $100,000 forfeiture. Abner's world collapsed around him. There would be a new world for him, his wife, and his children. His wife suffered a heart attack. His daughter had a stroke at age 31. And Abner went to prison. And Abner went to prison despite the fact that the Honduran Attorney General wrote to our Attorney General at that time and said, wait a minute, this is not a violation of Honduran law. He went to prison despite the fact that the Honduran government wrote an amicus brief in the 11th Circuit saying, wait a second, this is not a violation of Honduran law. He went to prison and he became a convicted felon. He's still a convicted felon today. The second person I want to tell you about is John. John was a fisherman. He sold his fish down in the Gulf of Mexico, not far from where I am. And he had a boat called the Miss Kitty. And John was picked up one day by the Florida Fish and Wildlife, a state agency that was deputized by the federal government. And this individual, even though trained as a federal agency officer, had his federal authority, as a state agency officer, had his federal authority. And he charged John right then and there with a civil violation because he had 72 undersized grouper fish. And that's wrong. And we need to protect our fish. I agree with that. He gave John a civil citation. He told John to take the fish and bring them back to shore. John didn't listen. He threw 3 fish overboard. And those 3 fish overboard caused him to get charged with a violation of 2 federal felony statutes. Section 1519. For throwing these 3 fish, which they considered to be tangible objects, he was subject to a possible penalty of not more than 20 years in prison. And he was charged with this crime, and he was convicted. John had no criminal record before. He was a simple fisherman. He was facing this felony record of 20 years and now convicted. He went to trial. He also did not plead. But there's more to the story. You see, John was convicted of the 2002 Sarbanes-Oxley Act, an act that was created to deal with financial fraud in our government, an act that was created as a result of what had happened in Enron and the entire Enron debacle. He was convicted of the Anti-Shredding Act for violating a statute titled Destruction, Alteration, or Falsification of Records in Federal Investigations and Bankruptcy. But John's case was different than Abner Schoenwater's case, because the United States Supreme Court this time took the case. And this time the justices of the United States Supreme Court looked at whether or not this particular prosecution was proper. Justice Scalia asked the Solicitor General arguing the case, what kind of mad prosecutor would try to send this guy up for 20 years or risk sending him up for 20 years? And Justice Roberts, after he heard the Solicitor General say that this guy had disobeyed, that he had launched a convoluted cover-up scheme, that he had destroyed the evidence and listed people, including his crew members, Justice Roberts' response to this was, You make him sound like a mob boss or something. And Justice Breyer, wasn't what the government official was investigating, a minor crime, catching a fish that was too small? And Justice Kagan, I take it there are many state statutes, are there not? And Justice Ginsburg said to the Solicitor General, you in your brief point to the model penal code as a model for section 1519, but the model penal code makes this a misdemeanor, and this is a felony. And Justice Thomas said no. And Justice Kennedy said something monumental. In questioning the federal public defender, yes, it was a public defender who represented John Yates, Justice Kennedy said, I understand the argument you make has considerable force about over-criminalizing. And this was the first time in a United States Supreme Court decision when it came out, reversing John's conviction, that we see over-criminalization mentioned. Over-criminalization is a word that's very important to me. It's a word that in recent times has brought together both Democrats and Republicans in coalition. The stories of John and Abner are very disturbing to me because they go to prosecutors, which some of you may become, and decisions you will make. I am a former state prosecutor. I prosecuted cases. I also am a former criminal defense attorney. And there are many cases out there that we have to reconsider. We're going to hear a lot today, and we've already heard a lot about all the different financial frauds that were not prosecuted. And one has to stop and think, why is our government spending so much time prosecuting Abner, Schoenheimer, and prosecuting John Yates? Now, yes, I want to make sure our group is protected, and I also want to make sure our spiny lobsters are protected. But maybe they've gone a little bit overboard on this. Maybe prosecutorial accountability and prosecutorial discretion needs to be re-examined. Prosecutors get to pick and choose which charges they're going to bring, who they're going to prosecute, who they're going to give immunity to. These are all prosecutorial discretionary charges and abilities. So prosecutors make some good choices, but sometimes prosecutors need to have oversight. And sometimes maybe we need to be thinking about where the decisions are being made. Because on the other side, I read the report that was done about Bernie Madoff. And one of the lines in the report, this was an investigation as to why Bernie Madoff had not been indicted for so long. And it said, despite numerous credible and detailed complaints, the SEC never properly examined or investigated Madoff's trading and never took the necessary basic steps to determine if Madoff was operating a Ponzi scheme. Had these efforts been made with an appropriate follow-up at any time beginning in June of 1992 until December of 2008, the SEC could have uncovered the Ponzi scheme well before Madoff confessed. There's a dysfunction here. We have a broken regulatory system, and we have a broken criminal justice system. I want to say that it kind of leads to why I'm here, because white-collar crime was not where I thought I would ever be looking at. I thought I'd be dealing with things like stopping the death penalty, which was a motion I presented with Professor Roger Clark to the American Law Institute. I thought I'd be a person that was dealing only with social justice issues for those in poverty. and for those innocence type cases. And although I still have a very strong pull in that direction, one of the things I've learned over the years is that you can sometimes accomplish more change in areas that you think the least about. And that's what white collar crime is to me. I look at something like former Senator Ted Stevens. There were so many cases in our system where discovery violations were occurring and nobody was noticing it. And then a senator, the white collar person, gets indicted. And there was a discovery abuse, and everybody notices it. The point is that sometimes the things that you think are the least possible directions you're going to be in, you can sometimes have the most impact in the direction you really want to achieve. And that's how I see white collar crime. The other point I want to end with is, I've learned to deal with coalitions throughout the years. Coalitions that the first time I sat down at the table with, and one of our past speakers spoke about, there was no way when I was asked to go to breakfast with the former Attorney General of the United States that I thought he would want to have breakfast with me or I would want to have breakfast with him, because we didn't agree on anything. But I learned that through coalitions and sort of figuring out what you do agree upon, that you can move the agenda forward. And so think about that as a way to try to achieve what you want to achieve. Sometimes you get associated with the wrong groups, and yes, that's part of the deal. But if the agenda gets moved forward and you can make a change, it can make a difference. Thank you.
So I'm going to follow Professor Sand and stand up here, ask a couple questions of our panel, and then I'll get it up to all of you. It seems like if it's not too late, we might change the title of this panel to Federal Felonies, the Fishermen and Financiers Edition. You know, the question also might be amended because it's rather simplistic. Do we go easy on white collar crime? I think we're hearing perhaps some differences between going after the small fry versus the big fish. And I promise no more fishing metaphors. But I guess I have, I'm going to start with, I'm going to, I guess, just throw out my two questions, so it doesn't have to come back to me and then sit down, and then we'll maybe each look to this. One comment Jesse made at the beginning was that one good prosecution could do a lot of good. The question of whether deterrence works came up for me. I know Peter mentioned that he would bring that up and didn't have time in his opening remarks, but we do see repeat offenders, at least repeat corporate offenders. The question is whether the reason why deterrence may not seem to work at the entity level may be different than whether it would work at the individual level. So I want to pose that question. And the second thing relates to some interesting new cases in the news. You know, prior to a conference like this, the panelists get on a conference call, you know, a couple of weeks before and talk about recent events. But you know, the thing is, in the area of corporate and white collar crime, every day there's almost a new headline. And so I want to raise with this two new headlines. One, I'm sure you've all heard about Wells Fargo and the 5,000 plus employees who opened millions of accounts without customer consent and charged folks. There was a rather paltry but good settlement with the CFPB, OCC, and some state regulators of Wells Fargo. And now some of the best television will be occurring on Tuesday when the head of Wells Fargo has to appear before the Senate Banking Committee and get grilled by Elizabeth Warren. That's on Tuesday. I'm not sure when it begins, but I can't wait. Yeah, now we hear that maybe there will be criminal charges there. The other bit of news is that yesterday,
also Senator Warren sent 2 letters. One was sent to the Inspector General of the Department of Justice asking why none of the referrals made to DOJ by the Financial Crisis Inquiry Commission back in 2011 resulted in any criminal charges, convictions, or jail time for 9 individuals and several more entities. That same day, she sent out a letter to Jim Comey, the person Jesse mentioned who used to be a U.S. attorney, is now head of the FBI, and said to him, hey, maybe she didn't say hey, but she said, hey, you know how you released all those, you broke precedent and you released all those documents explaining why Hillary Clinton was not prosecuted for the various email issues. Since you've done that, the public also deserves to know why no influential or high-ranking banker was charged. None of these folks that were referred to by the FCIC were charged. Why don't you go ahead and release your documents on that? So I guess my questions relate to just putting that out there, see if you all want to respond to this question about deterrence and about essentially these repeat offenders and apparent unwillingness to prosecute. Thanks. And I guess I'll start, whoever wants to start first. Why don't we do reverse order and have Professor Podgor speak?
Thank you. I actually agree very strongly with Jesse on deterrence. I think that deterrence does work in the white collar area. And I think proof of it is to look at the sentencing of individuals in the white collar area, because if you go back and look at the sentences, almost every one of them are in category 1, which means that they have no priors. And if they have no priors, then we're having an effect, a deterrent effect. And I also agree that in addition to that, the stigma in society is so great for a white collar individual that may not translate the same to a non-white collar individual that does serve as a general deterrent in society. But I disagree on one point. And that is, I feel that the problem is that they're not prosecuting people for the crimes that would have the deterrent. So for example, typically what happens is they don't prosecute them on the intricate financial fraud that has been committed. Instead, they prosecute them on what I call shortcut offenses. They prosecute them for false statements, perjury, obstruction of justice. The same flavor of having that deterrence, of letting people know that the conduct they've committed is wrong.
Well, no, go ahead, because you disagreed with the notion.
I guess on deterrence, well, let me distinguish between corporate offenders and individual offenders. I mean, the problem for a corporation is that you can have 200,000 employees. And so if somebody in this unit or some group in this unit violates the law, and then in a different unit violates the law, do you say that that's a repeat corporate offender? I'm not sure if that's an easy decision to make. But on the individual level, I guess the fact that those offenders are all in category 1 and have no history may just show that they've led the otherwise exemplary life and took advantage of their opportunity. They saw their opportunity and took it. I'm not sure that criminal history necessarily indicates. In fact, you'd be unlikely to be a corporate executive if you had 3 or 4 prior convictions. The reason I question whether deterrence works is that, let me pick out one area, which is, and it is the low-hanging fruit of white-collar crime, insider trading, where we've seen a number of insider trading prosecutions. We've seen people go to jail for substantial periods of time, and yet it does continue to happen. This is the group that should read about the sentences, understand what's happening, and yet it continues to take place. Why aren't those people deterred? I believe that's because they think only the dumb ones get caught, that they're smarter. Or, and this is true with a number of white-collar crimes, if you talk to those defendants, any number of them will say, I didn't think I was doing anything wrong. If you don't think you're doing anything wrong, how is a sentence against someone in a similar position going to deter you? Now, perhaps it will keep you from undertaking certain types of conduct, if you want to give it the label risky conduct, although I never care about risk as a term, because risk is only assessed really in hindsight, but perhaps it will keep you from engaging in certain conduct. But if you don't think you're doing anything wrong, the fact that somebody else got caught isn't going to stop you. So I'll leave it at that.
I guess, yeah, I would just build on what you guys have both said, which is that, you know, when you're thinking about corporate enforcement, we kind of conflate a bunch of ideas. One is that, criminally charging corporations or trying to enforce laws against corporations, and there I don't think our deterrents or our mechanisms have worked, particularly because they haven't been very harsh. So we have a settlement regime where we fine companies lots of money, but we don't have significant punishments like taking away their ability to deal, work with Medicare and Medicaid. So Pfizer has had a series of basically every single possible corporate settlement you can imagine. EPA and NPA, they've had subsidiaries plead guilty. But they keep having problems breaking the law. The culture is broken, but because there hasn't been a serious sanction, like for a year you can't sell your drugs in federal government programs, that would get their attention and would get the attention of all the other pharmaceutical companies, and I think that would clean things up. I think that when we talk about insider trading, we talk about these kind of cases that Ellen talked about, and kind of the over-criminalization. What I think that is, in my argument, is a symptom of the problem, which is that the prosecutors are not focused on the really meaningful crimes at the significant institutions conducted by the most important people. So they go after these low-hanging fruit stuff. But I think that, in fact, it's hard to know whether there's less insider trading. I'm not particularly a big fan of the insider trading prosecutions, but I think that my sense is actually that there are two effects. One is that there's less of it, and then two, it gets much more sophisticated because these are extremely intelligent hedge fund managers who have ways of covering their tracks. Plus, the Second Circuit on Newman and Chasen has kind of basically made a lot of insider trading legal. We can get into that in a second. But what I would say is, if you look at the deterrence factor, we had a pandemic of corporate accounting fraud in the late 1990s and early 2000s, Enron, WellCome, Philadelphia, Global Crossing, Sended, and we prosecuted almost every single company and top corporate executive from all those major companies. That was a big, successful round of prosecutions, I would argue. And then I think corporate accounting got much cleaner, thanks to those prosecutions and thanks to Sarbanes-Oxley. Not at the banks, obviously. We had a slight problem with the banks that people remember back to 2008. But aside from that, corporate accounting was fairly clean for a while. These things don't last forever, but I think it worked.
So, does someone have the microphone? Okay.
There must be some questions out here. Great.
I think the reverse question to does criminal law go easy on white collar crime is, does criminal law go too hard on people who are not white collar who commit financial crime? And for me in the state of Vermont, that's a crime called false pretense. And it's typically women who write checks or use credit cards, and they're in the prison now for very small amounts compared to what is not being prosecuted. So I'd ask the panel the question, is the reverse probably the question we should be asking?
And can I clarify, do you mean writing a check when there's no money in the account, trying to pass the check?
Yeah.
Okay.
I couldn't agree with you more. I mean, I think that a lot of the cases, they're easy to prove. And so the low-hanging fruit type of situation comes into effect. I think one of the things that, you hear a lot of, and heard a little say, one thing I do disagree with is I do not think that there has been a decrease in white-collar prosecutions. I think if I look at the track reporting system of Syracuse, I would say, yes, the numbers show there's an enormous decrease in white-collar prosecutions. The difference is what they're calling a white-collar prosecution may be different. And that's where I think the statistics are really not accurate in that regard. I think what is happening is you take a case like in the federal system, there is no white-collar category. It doesn't exist. Does it include computer crimes? Does it include antitrust? We don't know. And so as a result, some people are just using the fraud category, which would include that, the no account type of a check, and that may be on the state system and not even on the federal system. But what happens is that the cases don't get reported properly, because if you take a fraud case, what's happening in the federal system is often they're not charging it with fraud, they're charging it as RICO, Racketeer Influence or Crime Organization Act, I mean, the 1970 statute, which includes as a predicate mail fraud. And so if they have two mail frauds, they can use a RICO charge, not be showing as a white-collar crime. Same thing with the shortcut offenses. They're charging people with obstruction of justice, false statements, perjury. It may not be showing as a white-collar crime. And so I think that the statistics on whether white-collar crime has really gone down, I'm not convinced. I can't prove it otherwise, but I'm not convinced that they're accurate, the statistics. But I agree with you wholeheartedly. There are so many of those cases out there. Individuals who are sitting in prison that probably didn't know that what they were doing was necessary. They thought it was wrong, but there may be some reasons why they were doing it also.
And what you may find with the situations with the prisoners you deal with is you also have recidivism statutes. 3 strikes. Remember when 3 strikes and you're out became, and so you'll get cases where the third offense is an $80 bad check. I think that was the California 3-strike case, and that gets you life. And you're like, life for $80. Well, life for $80 with, and so that may be what happens. I mean, a normal bad check on a first offense, obviously you can probably tell us better, but I suspect may get you a diversion, but second, third. And of course, once you're in financial difficulty, once you've gotten into the criminal system and you have the fines and it takes on a life of its own. There's no escape from the system.
We have another question.
I'm curious whether you think that the overcriminalization problem should have a statutory fix, or whether you just think that scolding the prosecutors will straighten it out. I mean, it's a very hard thing when prosecutors bring stupid cases, and they have for eons. But the question is whether to go further and try for a statutory fix.
I agree with you. I mean, I can go back to an 83 case where a prosecutor brought a case on a mail fraud situation that dealt with a $162 check given to a winery, a distillery, and only sent 50 cents in the mail, and they charged that individual with a crime. The court threw it out. The court said, no, that's not what the mail fraud statute was all about. It was supposed to be dealing with frauds on mails. And this was not really, this was a fraud, but it was a fraud against a company. As far as the statutory fix for all of it, I mean, dealing with prosecutorial accountability, I think is important. I think we moved in the right direction on sentencing by giving the judges back some power. Personally, I'd like to see things codified like the rule of lenity. So where there's a constitutional question on a statute, it could go either way. Many jurisdictions, the federal system has adopted what's known as the rule of lenity. We're going to lean towards the defendant. But I think a constitutional statement in some way, and a statutory statement in some way would be beneficial there. Another thing I think is really important is we need to have statutes that have explicit mens rea in it. And I don't mean the speeding tickets. I don't mean the things that are minor misdemeanors. But I mean the things that are dealing with the crime that you didn't even know it's wrong before you're going to be prosecuted for it. I think and the prosecutor should have to prove that the person knew it was wrong. And you can do that. I mean, I've been a prosecutor. It's not difficult. When you show them the fraud, when you show all the actions the person has taken, you can prove it. But I am concerned about those instances where a person just didn't know that what they were doing was criminal. So in that regard, I think a statutory fix is important.
So, anyway, can I add? So this is where we really disagree strongly. First of all, I don't agree with the notion that white-collar crime or corporate crime has been over-criminalized at all. So I completely reject that notion. And I think that, in fact, you see over the last 15 years, prosecutorial power being rolled back and prosecutorial policies rolling back in response to corporate lobbying and the American Bar Association's corporate defense bar lobbying. And the main thing is the main example of that is the Thompson memo, where Thompson memo was Deputy Attorney General, you referred to it, memo about the cooperation regime for corporations. And that was viewed as overly aggressive and incurred on the attorney-client privilege. It was rolled back. It wasn't rolled back accidentally. It was rolled back because there was a concerted corporate lobbying effort about that through the 2000s. And in response, there was going to be some legislation, and then the Department of Justice sort of engaged in a rearguard action to rein in its own investigative techniques. But then you've seen a series of cases, rulings from the courts, a number of them, I won't list them all, I probably wouldn't even remember them all, but one example is the Supreme Court ruling on the honest services charge that was used for Jeff Skilling. The prosecutors started to take this charge that was used for corrupt government officials and transferred it to the corporate space and said that corporate officials have an obligation to give honest services to their shareholders, and Skilling and they were both charged with this in the Enron case, and then the government threw that out. So I think that they've actually been reining in prosecutorial power, not expanding it over the last 15 years.
I'm in the middle and I'm going to duck.
Okay, I have a question, but I want to have maybe give it to someone in the audience. Professor Yankah.
I don't get my shout. Yeah, sure. I actually just wanted, in this I don't have a lot of evidence. I just really am working on my very brute intuition. So I just wondered if
Do you give them the mic so more people can hear?
Oh. I just wondered if you could say more about your thinking that that there is a lot of deterrence. More importantly, you're thinking that there's a lot of stigmatization in white collar convictions, which kind of cut against my intuitions. Now, I suspect, of course, what is true is that many people who are convicted are people who are high status people, so they have a lot to lose in terms of their intuition. And I also don't take trivially that those who are then stopped from ever returning to certain types of financial work have lost a real means of living. And though they're wealthy and so easy to dismiss, one can ignore that, but that's quite serious. Nonetheless, the example I used was, partly due to what you were saying about how we undersell these charges, and partly due to the fact that these are intelligent people who can describe in a blizzard of words how confusing it was that they got caught up. I see white collar criminals tend to return back to very fancy positions in New York City and are treated only with the occasional shamed financier in the newspapers. Whereas people who come out of prison for robberies are typically just avoided as though they're actually metaphysically staying. And so I'm confused by your interpretation. I'd love to hear more.
I'm not going to say that the actual consequences to the non-white collar criminal are not devastating, more devastating than it is to the white collar person. In the respect that a non-white collar person doesn't very often have family support, doesn't have the resources to come back. And so as a result, I think that the actual consequences to the individual may be much, much harsher in the non-white collar scenario. But I do think that the white collar offender, the shaming is such a significant deterrence in comparison to somebody who's in a society where doing some time may not be or may be considered acceptable. And that's where I think there's a big difference. The other big difference I see in the recidivism rates. And I think if you look at, and some people will say, well, white collar criminals just weren't caught before. That's easy to say. But the fact of the matter is, if we look at the fact that the white collar criminal starts out with a level 1, which means they don't have a prior record. And some of those statistics are a little deceiving in some way because of the fact that they lump in under fraud many types of cases, some of them not being white collar type cases.
Can I just add two things there? One is, I agree completely with what you just said. I think that there isn't great data on this that I'm aware of. It's not particularly, so, it's not really what a journalist does, but for academic research, kind of trying to, I may not be aware of it, in which case somebody should make me aware of it. I would be very grateful, but I don't think that this is really been studied. But I also want to make the reverse point, which is that the lesson of the financial crisis is you can act extraordinarily recklessly, take high risk, high reward positions, literal investment positions that may give you very high bonuses, but also result in blowing up not only your group, but your bank and the world economy. And then you get to keep the gains, and you privatize the losses. What message has that sent? This is the reverse deterrence message. None of your friends, you did not go to prison, none of your friends went to prison, none of your bosses went to prison. And in fact, they're still feted and they are invited to the Aspen Ideas Festival and they go to the Met Gala. And so they are still, in literature you see, there's an Edith Wharton novel, I think it's Custom of the Country, where a guy blows up his bank at the turn of the century and is ousted from society. It's not criminal, but he's exercised. Today we embrace people who blew up their financial institutions. So not only is there no deterrence factor from putting them in prison, but there's no sort of societal cost for having blown up the world.
So I have one question, and Amit has one. We'll ask them together. And we've got 3 people. We'll bundle all 3 questions together and see what happens. You're transitioning from Jesse's comment about privatizing profits and socializing losses. I wondered what the panel thought, and tying into Ellen's comment on mens rea, on state of mind. There is this doctrine, responsible corporate officer doctrine. And recently there was a conviction of two executives, a father and son, the deposers from an ironically named company, Quality A, that had a massive salmonella outbreak. They were convicted of misdemeanors and sentenced to prison time. And under just quite, summarizing it quite simply, under the responsible corporate officer doctrine in statutes like the Food and Drug FDCA, Food and Drug Cosmetics Act, a person, even if they're not shown to have known about a particular problem that rises to the level of offense, and didn't actually take the action that is an offense, if they're at a certain level to have the ability to have prevented it, they can still be convicted and serve time. And I wonder whether you think that that's a fantastic doctrine and maybe should be expanded to other areas of law, or perhaps think it needs to be dialed back. Two more questions, you and there, and then Ahmed next. Thanks.
In preparation for coming, my students and I watched just the first few minutes of The Smartest Guys in the Room. And within the first 6 minutes of that film, the directors take us to the person who was president at the time. And I'm wondering, does who's president matter in terms of the prosecution of white-collar crime at the federal level?
By president, you mean president of the United States as opposed to president of the corporation?
President of the United States.
Okay. And Ahmed, you had a question, you want to put these all together?
Sure, and it's going to sound very similar to yours, Professor Taub, so I'm glad that a great line is one of the things we've been talking about, one consistency is that prosecutors share some blame for this, maybe the majority of the blame, either over prosecution or under prosecution, right? I wonder if we're missing the boat on the problems within the law and doctrinal issues incentivizing prosecutors to over-prosecute in certain instances and under-prosecute in others. So I'm talking specifically about evidentiary standards, what's needed to prove crimes, and of course that largely revolves around intent. So I'm curious, so this is now getting into, of course, what Professor Taub is proposing in terms of working around those intent standards in instances in which corporate officers, were in charge when the public health and safety was put at great risk and there was massive damage.
I think I might be able to get all three of these together. Does everybody know what happened 8 years ago, yesterday?
Lehman Brothers.
Lehman Brothers collapsed. And that is generally, although you could argue bear stearns, but Lehman was where things went south. Dick Fuld was the CEO of Lehman Brothers. And the question has been raised, why wasn't Dick Fuld charged? Dick Fuld did not open an email. He had his secretary print out emails, and then she brought them in a package. And prosecutors wanted to go after executives there for accounting fraud, much like back in the Enron, WorldCom, Adelphia era. And one of the things they said was, here's an email that they shifted liabilities at the end of quarters. They said, here's an email. And Fuld said, don't remember it. Well, you got it. Didn't you read it? Don't remember. These white-collar cases are all about intent. No one disagrees about what happened, ever. I have never heard, I'm desperate to hear of the white-collar case that has an alibi, in which the CEO goes, I was at home watching Dancing with the Stars when, so they're all about intent.
Actually, one of the CEOs was out playing golf, I should remember.
Well, that's right. Or there were the bridge players, Bear Stearns.
Playing bridge, excuse me.
But how do you
Smoking pot in the bathroom. Speaking of marijuana,
judge not? We all went to college,
Allegedly.
and so. And your question is, do you change those intent standards? Because you can't really change
the actus reus aspect of these. It's really the intent standard. Do you go with responsible corporate officer? This is the old line that was back in 2009, 2010. What we really need is Lloyd Blankfein, CEO of Goldman, going to prison. And the answer was, well, yeah, except there's due process. You got to prove he intended to commit a crime. And do you make CEOs liable for any wrongdoing in the organization without proving intent? That strikes me as a bad idea.
I do think the mens rea is very important, but I think that there is something to also consider, and that's the willful blindness doctrine. When a CEO says, I know nothing, I see nothing, I hear nothing, and it's right smack in front of them, and they might have the email, and they might have done some deliberate act, you've got your case. And you can prosecute those cases. So I think that is possible. Let me pass on the political question now.
Yeah, I would add a couple things. One, I agree that they're very cowardly, nervous about bringing charges like willful blindness because they're so reliant on direct evidence. So they want to see the emails, which makes these cases a lot harder. Two, I'd like to see mens rea expanded to something like blowing up your bank has a lot of social consequences and immiserates many people. So it could be kind of like a health and safety, regarded like akin to a health and safety violation. In which case you lower the standard and have a responsible corporate responsible corporate officer standard. Maybe we should have very much lower sentences. So we're putting away more white collar people, but we're not putting them away for as many years. To answer the political question, I have an opinion on that, which is that the evidence seems to suggest that the old style Republican presidents were better on law and order, or at least we have a case of George W. Bush was in 10 legs. The Bush family went back time, and then they managed to prosecute that company, and he did not interfere. They were serious law and order people. It's kind of the old style Republican view. And in my interpretation, the Democrats were more focused on systemic reform at that time, focused more on Sarbanes-Oxley than criminal prosecution. They thought, in some ways, the Democrats sort of approached this, and we don't want to just fix one bad apple or get a couple of people. There's a huge systemic problem with corporate accounting, and we want to have regulation to do that. Then you get the 2008 financial crisis, and the Obama administration is in there, and they again kind of focus on the systemic reform of Dodd-Frank and de-emphasize the criminal prosecutions. Maybe through ideology, maybe because they're kind of corporate Democrats and they're kind of friends with these people. There are a lot of different reasons, I think. But they forget that it completely undermines the credibility of your systemic reforms if it's not coupled with the appropriate level of punishment. And so nobody believes that Dodd-Frank is sufficient. Dodd-Frank is a terrible credibility problem. One reason is because it wasn't coupled with enforcement.
So this is great. We'll continue some of this conversation both at lunch and then on our final panel. Thanks everyone. Lunch is in Yates, the room across down the hall. And then when you get your lunch, bring it back here, and our lunch talk will begin at 1:45. Oh, yeah, 12:45. Yeah. Okay. Thank you.
So it ended up being yes. My name is Sissy, so when it shows up, I will. Thank you. And then I went to Nevada. I think some of the regulating fact that states obviously and addressing
You said that I didn't. And so there's no secret. So what's the distance for a high prosecutor to adopt those? There is no license. So,
It's like 10 minutes.
Eventually, yeah. Yeah, they're really good dogs. Probably 15 and 11 years old. They're super Oh, you said so at the table they have the science. you all been here? Did you just get here? Or were you the earlier? Yeah. The first one was really good. I really recommend watching it online. It was like amazing. I mean, I like this video too. I'm surprised. Yeah. What? I know. And the first one was like really good. It talked about not just the ideas, but also the experience of being a great student of rights. I like that. That's coffee.
Yeah, I'm not going to talk about it.
Then I may wind up somewhere else.
Folks, if you can just start getting ready to migrate back to your seats, we're going to kick off in just about 2 minutes with our keynote speaker. Thank you.
Microphones.
Yeah.
Oh, Jessica, I'm sorry, you're doing this one. Yeah, I am. Yes. Well, how about you? I do.
It's getting very quiet in here, so I guess you all know we're about to start the next portion of the symposium. And Jesse Eisinger, who we introduced earlier in the day, is going to talk to you about his forthcoming book, which if you didn't hear before, is tentatively or maybe definitely titled The Chicken Chip Club. And some of you are just arriving now, so he will probably maybe explain again what that is, and if he doesn't, he can ask me. He can ask me after. It's such an honor to have him here. He's a very, very generous person. Beyond the work he's done in investigative journalism, earning him, as mentioned earlier, a Pulitzer Prize for investigative reporting, he's also a very supportive colleague. Several years ago, when my book on the financial crisis was about to come out, I met with my editor, and he said, raise your profile. And I thought, okay, if someone gives me instructions, I'll do it. And I thought, how could I raise my profile? Maybe I should get a column in the New York Times. And I'm not sure how or why I reached out to Jesse. Maybe it's just a random email. And we had lunch together, we met together, and he introduced me to his editor, which was very, very kind of him. Anyway, and here he is again. So I really want to welcome him here and look forward to his explaining his, I think, a tremendous contribution to the field of white-collar crime, as well as I think it's a wonderful and important contribution to our theory about the financial crisis. I'm not going to step on his talk and tell you what he's going to talk about, but I will let you know that he's really the first person to, at least this chapter that he's going to be talking about, he's really the first person to introduce, to do this research, to support this theory he has about criminal enforcement post-crisis, to support it with this research, and to hopefully elevate, when the book comes out, elevate the discussion and hopefully further change. Anyway, welcome again, Jesse.
Thank you so much. Thanks again for inviting me to the panel and to give this talk. Both the students and Professor Taub, I really appreciate it. I realized that I had a sort of a neologism in my talk of exercise, so I was thinking my parents, you heard about my mother thinking like, Jesus Christ, he can't even get his words right, he's going to give a speech. It's sort of a nice a combination of ostracized and extricated. And so then now I'm starting off in this august setting with a literary reference to the first Batman movie by Tim Burton, with Jack Nicholson as the Joker. And this is the story I'm going to tell about the Department of Justice and big law. So stick with me for a second. If you remember that movie, and some of the students were probably not even born when it came out, it's non-canonical Batman. But what happens in this movie is that young Bruce Wayne witnesses his parents getting shot by a robber, grows up to be Batman, and then chases that robber down into a factory where the robber falls into a vat of acid and becomes the Joker. So the Joker has created Batman, the man who becomes the Joker has created Batman, and Batman has created the Joker, right? So they're both responsible for each other. Well, so the Department of Justice and big law are both responsible for each other. And I'm going to kind of give this, lay out what I've kind of realized through my reporting and research. I should make, before I get into that, I just want to say that I'm very flattered to be giving this talk. I'm a reporter. The best reporters are humble people who listen, and I've not always been as humble as I should be, but I have gotten to be a better listener. And I have read and listened to so many people in this room, Professor Taub, Bill Black, Ellen, Peter Henning, Rena, and so many others, that I kind of feel slightly silly standing up giving a lecture or a talk, but here goes, and I'd be interested to hear your thoughts on it afterwards. So we should open it up for Q&A. But so I'm going to give sort of 4 parts to this story, and the story really goes back to the 60s and 70s. And the part 1 is that the feds start eyeing bigger targets. And the story starts with a couch, Stanley Sporkin's couch. Stanley Sporkin was a larger-than-life character, huge man, and a legendary figure as the SEC's director of enforcement throughout the 70s. And many people think of him as kind of the father of enforcement. He invents, in many ways, the modern SEC and the modern SEC's approach, and he does it mostly from the most hideous piece of furniture in the history of government. It is this ugly couch with terrible greens and yellows. It's kind of like a hallucination from an LSD trip, from a 1950s suburban house, and it was stained. He ate lunch on the couch a lot, and he made no concession to the food in his mouth when he had a thought. So lots of Jello was out on the couch, and sometimes the lawyers at the SEC would see mice running in and out of that. And Sporkin had a technique where he sat on this couch deep into its cushions, and lawyers would come in, big Tony firms, white shoe lawyers, very buttoned down, proper, and they would give these extensive and well thought out defenses of their clients. And Sporkin would sit on the couch and lean back and close his eyes, and no one had any idea whether he was asleep or not.
And these defense lawyers were totally discombobulated. They're thrown off their game, and they're like, well, are we supposed to continue here? Are we supposed to go on? What's happening? Is he asleep? And they sort of continue with their talk, and then he would leap awake. He'd been listening the whole time, and he would zero in on some piece of bullshit that the defense lawyers were spinning and attack it incredibly incisively. And people would fall to this game all the time. So Sporkin, and he's not alone in this, but Sporkin is credited with creating access theory. And access theory is the notion that the enforcers, SEC and the Department of Justice, should start to go after a higher class of criminal. But in the sort of 40s and 50s, the SEC and the Department of Justice, which is really the Southern District of New York, as I was saying earlier in the panel, really go after kind of two big criminals, Ponzi schemers, boiler room operations. They really rarely go after major corporations and big serious targets. And Sporkin has started this, and it's really started also with Robert Morgenthau as the U.S. Attorney in the 60s in the Southern District. And Morgenthau says, how do you justify prosecuting a 19-year-old who sells drugs on the street corner when you say it's too complicated to go after the people who move the money? Which I think is an extraordinarily prescient and timely admonition even for today, as we heard this morning. So both the Southern District and the SEC kind of raised their targets. And Sporkin wants to go after the access, the companies, the firms, the professionals who give access to the markets to bad companies, meaning accountants, lawyers, and investment bankers. The people give access, they vet the numbers, they clear the documents, they get the capital for these companies. And he has a very smart idea, which is these guys are gatekeepers, they're responsible, and if we prosecute and sanction the accountants will clean up their act, and we'll have this cascading effect. So we're not just going to focus on one company because we're going to leverage our enforcement action. So one example is a big fraud, marquee fraud at the time called National Student Marketing, and Sporkin finds out that the company was making up a lot of numbers, kind of very extensive fraud, and he calls up a buddy in the Southern District, a young prosecutor named Jed Rakoff, who many of you now know as a federal district court judge, and probably the preeminent legal world critic of the Justice Department and how it approaches white-collar crime today. And Sporkin says, we gotta go get these guys, and not only that, we're gonna go after their accounts, two P. Marwick guys, and they prosecute the accountants. And then Sporkin says, now we gotta go after the lawyer, the White case lawyer. And the Southern District basically decides that they don't have enough evidence, and Sporkin is furious and screaming at them on the phone, and the SEC sanctions them, and it becomes one of the most important cases. So step one, and this giving a very quick flash of history here to get through to the point here, but step one is the feds look upward. So step two is that big law notices. So before this happened, the white shoe law firms, the most prestigious law firms and important law firms in the country, did not really do criminal practice, criminal defense work. And they didn't do it because it was disreputable. You had to mingle with not a particularly nice class of people. They had a higher opinion of themselves. In Washington, they talked about Fifth Street lawyers who'd be drunk at lunchtime doing this kind of stuff. And so the best law firms outsourced if a CEO got in trouble, which was rare, they outsourced that kind of stuff to boutique law firms. But Deborah Boys and Clinton didn't do
But what's happening then is that the SEC and the Department of Justice are starting to focus on higher classes of individuals, and therefore they realize that, well, there's some defense work here. And I should add that this is all at this point about individuals, individual prosecutions, because the SEC and the Department of Justice at that time don't see any point in prosecuting corporations. They don't even, it doesn't really occur to them to prosecute corporations. Corporations are pieces of paper. If you prosecute a corporation, you can't put it in prison. And the best you can do is levy a fine, and the fine hits the shareholders. And so they think that's pointless. So what we should do is focus on individuals. So they focus on higher class individuals, and then big law notices, and they start to think that this is respectable. And so they start hiring prosecutors to start up white collar practices at big prestigious law firms. And so guys start going from the Southern District to big law for the first time in the 60s and 70s. And there's a guy named Pete Fleming, who's a legendary defense lawyer. He moves over from working under Morgan's Law, and a couple others. And the third person to do this is Jed Rakoff, who goes to Nixon's old firm, Mudge Rose, and starts a white-collar criminal practice. So step two, big law starts to build up these practices. Part three is that the federal approach to corporate crime starts changing this time, really starting in the kind of 80s and accelerates into the 90s. And what's happening then is that the feds are taking a page from mafia prosecutions. And they're saying, when we prosecute individual soldiers in the mafia, we don't root out the problem. We don't solve the systemic problem of the mafia family. So what we need to do is try to get everybody in the group and try to think of this as a family, a system, and they flip at people to get to the top. And this has an influence on corporate prosecutors, but corporate prosecutors take it in a slightly different direction. They think we need to root out the problem of corrupt companies. We have to address the culture of companies, not individuals, because a corrupt company can slot in an honest person as a CEO or a CFO, let's say, and corrupt them. So what we want to do is sanction the company as a whole. And so the first occasion for this is the Salomon Brothers Treasury scandal, where they decide we're going to have a sanction for the corporation now. It's no longer just individuals. We're going to move to try to sanction the corporation. And then they do something called a DPA. Mary Jo White in the Southern District in 1994 does the first deferred prosecution agreement for Prudential Securities for a whole host of complicated reasons. They come to this agreement. What is a deferred prosecution agreement? Deferred prosecution agreement, it comes from the juvenile courts, where prosecutors with a lot of discretion said, we're going to charge you, but we're not going to actually carry through on this charge. We'll let you, you juvenile, you're young, we'll see if you don't do anything wrong for the next 3 years or so, and then if you do, we'll bring these charges, we'll unveil these charges that we have. If not, we'll drop the charges. And so they transfer this from the juvenile courts to corporate setting and say, we're actually going to charge you, we're going to write a piece of paper saying we're charging you, but we're going to defer the prosecution for Prudential Securities. And so this is a new model for corporate charges. And it's a very good model for big law, because big law does the internal investigations of the companies that are under federal scrutiny. Suddenly, this is a very lucrative business for big law, much better than representing the individuals, because the individual defense is kind of a one-off. But if you have a corporate client that's running into problems or needs huge compliance, this is an ongoing, it's a money stream that's ongoing. This is like, instead of a pill that saves your life, you take it once, this is the ongoing chronic treatment for AIDS or for cancer or for, it's a wonderful, a cholesterol drug. It's a wonderful kind of ongoing revenue stream for big law. Prosecutors start to really like this system because it's much easier. It's much easier to get the corporation to the table. The corporation has to cooperate because they are worried about the death penalty for the company being put out of business. So they come to the table. They're really just negotiating about money at this point. And you can wrap up these prosecutions and get a DPA much more quickly. Individuals will fight. They'll go, they'll have very good lawyers and they may even go to trial. They're going to fight a long time because it's about their livelihood and it's about their liberty. And so prosecutors are finding out that this is a kind of very attractive way of sanctioning corporations, and DPAs explode. So in the first 10 years, roughly, of DPAs, the Department of Justice says, I'm kind of going to make up the numbers a little bit, but roughly about 25. And then in the following, roughly following sort of 10 years, 12 years, they do about 260 of them. So DPAs explode. And so part 4 is that big law then evolves in relation to this, and I've kind of alluded to this, which is that they not only build up big white-collar defense practices, but the big white-collar defense practices move into this area of conducting the internal investigations to provide to the Department of Justice to show that they're cooperating with the investigations so that they can get a DPA. And you see this in a series of law firms, the story of these law firms, but I'm looking at Covington & Burling for the book, the big, powerful DC law firm, old line, white shoe law firm. And the reason I'm interested in it is, many of you may remember, but Eric Holder, the first Obama Attorney General, comes from Covington & Burling. Lanny Brewer, the first head of the criminal division for the Obama administration, comes from Covington & Burling. Covington & Burling is part of the kind of secret or unacknowledged Washington permanent government. They're not alone, but if you have to think that if you have to choose between who's running the country, is it Congress or is it the Covington Burlings in the world? I would say probably the Covington Burlings. And so they're founded in 1919. Dean Acheson, who is Truman's Secretary of State, is a partner. In the 70s, they're a leading firm. I'll give you some numbers. In 85, they have $49 million of revenue. They're the 37th biggest firm in the country. Profits per partner, $215,000. In 1999, they're falling because all the firms are building up big white-collar practices. The white-collar practices, very attractive businesses, as I was saying. One of the reasons is the high margin business, very lucrative. Partners in white-collar practices make more than partners in other kind of practices. Not the most, probably bankruptcy is probably the best for big law, but white-collar is very good. It's nice business to be in. So Covington buys a New York law firm. They get a white-collar practice. They start building it up. And then last year, now they're up to $709 million in revenue in 2015. They're making $1.3 million. Lanny Brewer was making about $4 or $5 million a year. And they're doing all these investigations. But big law has changed in the intervening 3 decades. And they're going through this kind of internal identity crisis because people think that the business is very mercenary and commercial in a way that it didn't used to be. We were talking yesterday at dinner about whether this is a kind of nostalgic notion about what the law was. And I don't think it was. Obviously, there's a lot of nostalgia. There were a lot of pernicious aspects to big law in the 1960s. There weren't women, there weren't minorities, but there was a kind of oligopoly, and you had clients for the long term. Corporations weren't shifting away, and you could afford to tell your clients more of the truth than you can today when clients will drop you. And these firms were run by lawyer statesmen, what you call lawyer statesman, which is a kind of public-minded, intellectual leader, not necessarily commercial. Not every law firm, but many of these firms. Today, the lawyer statesman doesn't exist anymore, and this is a lot of anxiety. I'll just read one excerpt from a study in the law review. There's widespread agreement that the legal profession is in a period of stress and transition. Its economic models under duress. Its ethical imperatives are weakened. And so there's this commercial aspect of the business that's happened as they conduct these internal investigations, as the white-collar defense business becomes so important and so lucrative and much more mercenary. So the irony is that even though these firms are bigger than ever, even though they're making more profits than ever, even though the partners are getting paid more than ever, they have much more business anxiety. And so the prosecutors are using big law to conduct these investigations. As big law is changing to have this become a more prominent part of their business, but also become more business-minded and more mercenary, more commercial, and less able to ethical work. And Sam Buell, a scholar in Duke Law School, says that the law now treats the corporation both as cop and criminal, uses the corporation as a vehicle for detecting, proving, and punishing. So what are the consequences of this regime where you've had lawyers working so closely with big law and creating each other and sort of influencing the way the business runs in big law and the way the prosecutions work, because the prosecutions are so dependent on the internal investigations conducted by the law firms to reach their DPAs, which they find to be easier to do than individual prosecution. Well, I would say three things. One is that it erodes the skills of the prosecutors, because the prosecutors are so dependent on how to conduct these investigations, they can't do it themselves. And so they've lost the skill set. And I think this is a real problem, and they've been reined in by the courts. There are a lot of things going on, but one of the things is they've lost the skill set to do what they needed to do and what they used to do in mob prosecutions, what they've done in the most successful white-collar corporate prosecutions, which is start at the bottom and flip individuals and work their way up to the top. That's painstaking work. It takes years. It's very expensive. The prosecutors are cycling out of the Department of Justice, and you need to have historical knowledge, institutional knowledge of the cases. That's much harder than reaching these DPAs, and so the skills of this are eroded. The second consequence is that it allows the corporate executives at the top echelons to skate free, because the internal investigations from the law firms are studiously incurious. They are very professional and very slick, and these are some of the smart people in the country working on these. I admire their intelligence. What they do excel at these big law firms is not asking the questions that will lead to uncomfortable answers from the client. And if you go after the CEO or the chairman of the board, you're not going to get the next assignment from the next corporation for the internal investigation. So you find the subsidiary or the executive at the subsidiary, and you write an absolutely damning, very convincing internal investigation about that person, or a few people, but surprisingly enough, you haven't found anything on the CEO. And because the prosecutors don't
know how to kind of build those cases anymore. They can't bridge that gap. And so I guess that brings me to the final point, which is that this is self-reinforcing. That all of this works together. And that the Department of Justice has become a way station for young people to stay for a few years before they go and take their big law firm job. It's like a postdoc where you're studying a little bit before you get to actually take your real job. And it used to be that big law said, we're hiring prosecutors for their trial skills, for their litigation and trial skills. But they don't do trials anymore. They do settlements. So what's really going on is that big law is valuing the prosecutor's skill set, which is their settlement negotiation skills. So they're valuing for two things. One is how they negotiate, and two is the institutional knowledge of the Department of Justice to see how they'll view certain kinds of behavior. And the negotiating is really important because when you're negotiating with people who are more experienced than you, young prosecutors negotiating with the partner of the law firm. Partner of the law firm generally has, not everybody, but this is generally true, more experience, probably was a very well-regarded senior person in the very office that you are now in, and holds the prospect of your future employment in his or her hands. You are going to want to show that you are brilliant and thoughtful and imaginative and aggressive up to a point. But you don't want to be ultimately unreasonable. You don't want to be a son of a bitch. You don't want to be a man or woman. You want to be a man or woman of proportion. And so ultimately, you are going to reach an agreement. Because you want to be a person that can that the person who you're sitting across the table from thinks, I could see this person sitting at the right hand in a few years. And so they've created each other, and they've created a system that is terribly broken if we want to hold corporate criminals personally accountable. The end.
So we're gonna have some questions. Is the mic, where's the mic?
Jennifer's got it. She's on it.
Okay, in the front row, Professor Steinzer.
Tell us just a little bit about corporate monitors under these DPA agreements.
Well, Brandon Garrett is really at UVA, is the expert on this. The corporate monitoring system is terribly broken. So I'll explain what that is. So the Department of Justice has the ability to hire a monitor generally from a law firm, generally a former government official, now at a law firm, to oversee these DPAs and enforce these DPAs, sometimes NPAs, sometimes DPAs. And so at one point, they kind of randomly assigned monitors on occasion. Sometimes these DPAs had monitors, sometimes they didn't. There was no rhyme or reason. And that was a problem. Chris Christie was appointing his buddies to do corporate monitorships when he was U.S. Attorney in New Jersey, and that seemed like a problem. Then these guys were charging huge amounts of money. So there has now been a little bit of codification of this, nothing in actual writing. One of the real problems with the Department of Justice is I don't think that they have much policy apparatus, and they don't sort of think about processes and
codify these things. So, but now, kind of on an ad hoc basis, we essentially have monitors for almost every DPA, an MPA. But it's essentially the exact same problem, which is that they're coming from who have a cottage industry in being monitors. And again, if you have an ongoing lucrative business monitoring these DPAs and NPAs, and you're too much of a pain in the ass, the company complains about how much they're paying. They complain about, sometimes they take you to court. And they've actually taken monitors to court when they're too difficult. And they throw up a lot of resistance. And the Department of Justice isn't particularly set up to do either oversee its DPAs by itself, or to really kind of oversee whether the monitor is doing a good job. So what I think should happen is that they need to build up the apparatus to do it themselves. Yeah.
So I have a question. You mentioned that these big law firms that have these white collar practices, they do the investigation of the corporation that's being charged with these financial crimes. Like it just seems crazy to me. Like where is the oversight? Like,
yeah, it's bad. It's really bad. Well, so what the Department of Justice says is, this is a way for us to leverage our resources. And we can't, there are two things we can't do. One, we can't police all the corporations that are doing bad things in the country, which is a problem in and of itself, I think. They might think like, geez, maybe we have a bigger problem on our hands if we've got so much rampant crime corporations. The other thing is they say, well, these companies are sprawling global international companies, and we can't go around the world interviewing executives in Tokyo and in Sao Paulo and trying to build up this whole case. We just don't have the time and resources. So we need to outsource this to big law firms. But we're still going to do the investigations. We're just going to have the big law firms help us out. And we're going to make sure that the big law firms are doing serious investigations, because we're going to say, like, if this is not serious, that we're going to find out, and you're not being cooperative, and if you're not going to be cooperative, we're going to punish you even more. The problem is that they don't really hold them accountable for any of that stuff. So in the Toyota case, where Toyota was lying about the safety of its vehicles, Toyota said, go fish. We're not going to make you. We're not going to make executives in Tokyo available for interviews. And the SDNY was really mad about this, and they said, we're going to punish you a lot for this, and they're like, we're still not going to. And so he said, well, we're going to raise the amount of money that we're fining you. And so they raise the amount of money, and it all comes out of shareholder pockets, and there's no real serious sanction, and that's that. So it's a really ineffective system.
So I had a friend recently say to me, all these folks like myself were wondering why no high-level bankers were prosecuted after the financial crisis. They said the simple explanation is that they didn't commit any crimes, which is a possible explanation. And the person said if there was a case to bring, pre-Ferrara in the Southern District, we brought it. I mean, he's this great, well-known, successful prosecutor. Why wouldn't you want to bring those cases? I'm wondering if you have a response to that.
Yeah, so, right, it is possible that no one in the financial crisis, in the lead up to the worst financial crisis since the Great Depression, and during and its aftermath, committed a crime. I find that slightly implausible. I also think that I've actually never talked to an honest prosecutor who actually thinks that. Almost every prosecutor says, I didn't see anything that was worthy of criminal prosecution in the financial crisis, but I can't believe that, insert here, Dick Fuld, Angelo Mazzillo,
XYZ were not prosecuted. So everybody has their favorite case that they thought should have been prosecuted by someone, just not me, because I didn't do anything wrong. It's not true. It's strange credulity, that argument. The prosecutors don't believe it. You also have seen things that are crimes that were prosecuted. So the one guy that I wrote about in the Sunday Times Magazine was prosecuted for a crime related to financial crisis. He's one guy from Credit Suisse, and he oversaw some traders who mismarked their portfolio, lied about the value of the assets on the portfolio. You'll be shocked to know that those three guys were not the only people to lie about the value of assets on their at their banks in the financial crisis. He was at Credit Suisse. But that happened, and every single Wall Street executive will tell you that happened. But the fact that they only prosecuted one means to me not that no one else did it, but that that there was a terrible failure of prosecuting and prosecutorial imagination and will. And then finally, specifically on Preet, I think Preet has been an aggressive prosecutor for New York State crime. Sheldon Silver is an admirable prosecution. But I think what the real problem was is that they focused on insider trading. They had all these insider trading cases. They had over 80 of them. They prosecuted way too many of them, I think, in my opinion. And there was a resource question. And the resource question was, do I take these birds in hand, or do I try to work on CDO cases and toil away for 3 years where I don't even know if there was a crime committed in this infernally complicated thing? The individual prosecutors, if you talk to them, you have a lot of sympathy for them, because they say, look, we had wiretap evidence in these insider trading cases, and we were in the room, we could hear these hedge fund scumbags insider trading and destroying evidence, and it was really sexy and exciting. And then we had this dead paper from 4 years ago about mezzanine transactions, tranches of CDOs, and it would have been so hard, and so so I do have some sympathy for that, but just because your job's hard doesn't mean you can't do it. So I think it was a terrible failure, a leadership failure, not just Preet, but Holder, Brewer, everybody. Yeah, back there.
Hi. I'm so fascinated with your talk. I clerked for a judge in 2007 who was from Covington and Burling, and went from there to work at a white shoe law firm in New York City, where Rudy Giuliani was a partner. And he had been, for those who don't know, U.S. attorney for the Southern District of New York. So all the attorneys I worked with were from the Southern District. I worked in a white-collar criminal investigations division, so we were conducting the very investigations you're talking about. So it's so fascinating for you to talk and sort of get perspective on my own life and what I was wittingly a part of. And I subsequently left, and I teach here now. But I was curious as to your perspective.
Rats, I'm getting out.
What's the recipe going forward for change? I saw clearly that maybe this starts in the prosecutor's office. At the same time, I saw the complexity of the financial world. And how do the prosecutors and FBI and SEC keep up with the sort of evolving complexity of financial products that are a root of some of the fraud? So anyway, I'm just curious, from your perspective, what's the recipe for a change?
Yeah, I think there are a variety of things that DOJ should do. One thing I think that they should hire differently. They should get, right now they hire, the vast majority of people they hire are young people from the elite law schools. And I think those are the wrong people. I think that those are people who are very smart, very capable, but generally rule followers and people pleasers. And the job of a prosecutor is to piss people off and put them at risk. Powerful people. And these people are not really used to doing that in their lives. So I hope you can go to a movie. I hope I'm not describing you personally. But I hope you piss people off in the first time.
So I think they need geographic diversity from other types of law schools, and I think that they need age diversity. I think you should get much more experienced people, older people, people who are refugees from big law, don't want to go back, and don't particularly like those sons of bitches who are making them work those many hours, so that they're not really that interested in negotiating in a nice fashion with them. So that's one thing. And then I think they need to be much more aggressive on appeals, retrials, statute. So that sometimes they back off on these cases when they shouldn't, the DOJ that is. And then the third thing is I think that there are some sort of statutory lobbying that they need to do to kind of they've lost some prosecutorial power over the last 15 years, which I get into in the book, but I didn't get into in the speech, but I sort of alluded to in the panel, but I think they need to figure out how to plug those holes, maybe not exactly with the same, restore those same things, but to analyze it. And I just don't think they actually analyze it that well, because it is a weird bureaucracy, the Department of Justice, 94 offices, they're all sort of ship's captains, navigating their own ships, and they try to tell Washington to fuck off as much as possible, and so there's no real sort of really serious policy apparatus or thinking about their powers in a kind of serious, holistic way. Yeah, is that it? Okay, last question.
One second, wait for the mic.
We've been talking a lot about it today. So I have a question. What does the DOJ or the SEC, or if it's like financial sanction, do with the money raised from fines?
They get lots and lots of money. Some goes just directly into the treasury. Some goes to victims, restitution for victims, which is an important part of what prosecutors think about their jobs. And then some of it is actually not money at all. It's just the DOJ claims it's money in the press release, but actually it's things like credits for modifying loans that count toward it, things that they might have done anyway. So there are a variety of things that they do. The money isn't unimportant. I'm not in the kind. There is a camp of people who think that we shouldn't prosecute corporations at all. We should just focus on individuals, and that the money, getting money through fines is a completely wrong-headed regime because you're punishing the shareholders. Shareholders are probably new shareholders, and not the shareholders of the company that who own the company when it's doing bad things. I don't really agree with that. I'm not entirely about that, but I think that there needs to be a prosecution of individuals to make this a balanced system. All right. Thank you very much.
Okay, so we have about a 10-minute break, and we'll get started again at 2 for our final panel. Thanks. Oh, and there's snacks. Afternoon snacks over on to my left.
Hi guys, this is a 2-minute warning, so just start taking your seats and get ready for the last panel.
I think there's not many choices back here. And chairs. Yeah, I know.
Thank you. Yes, I was in the middle of a project. Yes.
So welcome back. A couple of reminders if you missed an earlier session or if you will need to leave. We are live streaming this, and once the program is completed, it will be up forever, I think, on our YouTube channel. So please go back there. If you need to know the URL of that, I think if you go on Twitter, the BLS has pushed it out through Twitter. If you don't do Twitter, email me. I'll give it to you. If you don't do email, I don't know what to tell you at this point. Okay, so welcome to our last panel. The intention of the Vermont Law Review, who set this up, is that it's somewhat of a synthesis, but mostly beyond that, an opportunity to talk about policy in the future. There's this expression that people use, and they say some things an embarrassment of riches, but this, today's panelists have been. I mean, I've been, I thought I would be impressed and enlightened, but it goes beyond what at least my expectations were, and I think we're up for equally wonderful talks the remaining session. I'm going to, the panelists will be speaking in the order they're seating. The first person here is attorney Dan Seaton. Am I pronouncing the last name correctly? Awesome. He is a partner in the law firm of Seaton and Erickson, which is right here in Chelsea. He practices in all areas of criminal law. This includes grand jury appearances through jury verdict and appeal. He has tried over 100 cases to jury verdict and has obtained acquittals on behalf of his clients, ranging from charges of murder to illegal possession of an alligator. I do want to hear about that, getting the aquatics discussion we've had, but maybe not today. In addition, Mr. Seaton represents clients in administrative hearings, professional license proceedings, and as a trial counsel of complex civil actions. He has testified as an expert witness in numerous post-conviction relief and legal malpractice actions. He previously presented on criminal law procedure, evidence, and trial practice at the Green Mountain Criminal Defense Institute summer seminars, the Vermont Bar Association, Vermont Law School, and Vermont Technical College. The most important thing about him, though, of course, is that he earned his JD degree, cum laude, from Vermont Law School. So welcome.
Thank you.
Next to Dan is Amit Naram, and I know his bio is right here. I could probably do this though without looking. Amit Naram is a regulatory policy advocate for Public Citizens Congress Watch Division. He is an expert on the federal regulatory process, and he has testified before Congress many times on legislation and issues relating to executive branch administration of the rulemaking process and congressional oversight of federal agencies. He's been quoted by various media outlets, including The Times, the National Journal, NPR, The Hill, Bloomberg, Reuters, Huffington Post. And he's appeared on TV, radio, broadcasting for NBC News, and The Big Picture with Tom Hartman. Amit is also an attorney, and when he was at American University, he was an editor of the Administrative Law Review, and he's currently on the Law Review's advisory board. Welcome on. Amit's left is Professor Rena Steinzer. Professor Steinzer is a professor at University of Maryland, the Francis King Carey School of Law. She is the author of a wonderful recent book called Why Not Jail? Industrial Disasters, Corporate Malfeasance, and Government Inaction. Steinzer was a founder, the former president and member, scholar of the Center for Progressive Reform, known as CPR. I guess it's trying to revitalize justice. It's a think tank comprised of some 60 member scholars from universities across the U.S. Professor Stetson has also testified before Congress on several occasions, most recently regarding the impact of health, safety, and environmental regulations on the economy. She began her legal career in 1976 and entered academia in '94. She's practiced in private practice, representing cities, counties, states, and public agencies in the energy, environmental, communication, and transportation fields. She is the practice counsel for federal, state, and municipal clients regarding compliance with federal and state laws and regulations. Welcome, Professor Stetson. And our last panelist is Professor William K. Black. Bill Black is an associate professor of economics and law at University of Missouri, Kansas City, and he is the distinguished scholar in residence for financial regulation at the University of Minnesota Law School. He is a white-collar criminologist. He was the executive director of the Institute for Fraud Prevention from 2005 through 2007. He previously taught at the LBJ School of Public Affairs at the University of Texas at Austin and at Santa Clara University. He was litigation director of the Federal Home Loan Bank Board and deputy director of the FSLIC, that's the precursor, that's the FDIC equivalent for the savings and loan, which has now been subsumed. He was a senior vice president and general counsel of the Federal Home Loan Bank Board of San Francisco and the senior deputy chief counsel of the Office of Thrift Supervision, which was also abolished and then subsumed by the OCC. He was deputy director of the National Commission on Financial Institution Reform, Recovery, and Enforcement. His regulatory career is recently profiled in a book by Professor Capucci called Unsung Heroes. He's the author of the book with possibly the best title ever, which was The Best Way to Rob a Bank is to Own One. He's a regular columnist in various news media. He's appeared on television so many times you probably recognize him. And he is, like our fellow panelists, happy to be here to react and respond to what's come before, to tell us how to fix everything so we can go home happy. Okay, no, I'm kidding. So we can go home angry and make a difference. Okay, welcome, Bill.
I just want to say we're all here because we like Jenna. Did you hear that, Mom?
Reminds me of the time that I went to court early in the morning with my client to select a jury. That's what we were there to do, and the judge went around the room and asked all the attorneys, "Do you have a deal? Do you have a deal?" Most of them did, and she got to me and said, "Do you have a deal?" I said, "No." She said, "What are you going to do?" I said, We're going to pick a jury and try the case." And she snorted and proceeded to ignore me the rest of the day. And the jury kept late through lunch, and poked at by lawyers and prodded and inflamed. And finally, at about 3:20, she turned to me and said, "Okay, jury's all yours. So you got him." So I'm not a policy guy. I'm a practicing attorney. And if I have a policy, it is to not lose the trial. Because if you lose the trial, your client most certainly will pay the price of sentencing. For about 15 years, I was the sole public defender in Orange County, Vermont, which is a large geographical area that is sparsely inhabited. But the people that do live there are kind of wild and get in a lot of trouble. And so there was one public defender, and that means pretty much, these are poor folks too, so that very few private counsel. So whatever happened came through me, which gave me a certain perspective. I suppose that's what I'm here to share. Now, let me just talk about recklessness, criminal negligence, and young men. Because if I can talk about that, I can talk about 85% of the criminal cases in the courts today in Vermont, in my experience. Recklessness, criminal negligence, and young men. I have spent a fair amount of every day for the last many years appealing to judges and prosecutors to try to understand, grant some leniency, and preserve the lives of, and preserve some future for young men who are negligent in their actions. Now, in sentencing, early on in my career, I was horrified to learn how jail gets thrown around. The idea of jail. The idea of jail not just as a loss of time, not just years of your life, but as a quantum of suffering. That's really what it is. Unlike other panelists, I have never been to a nice jail. I have never been to a good prison. They are absolute hellholes in my experience. I hate being inside jails, and I'm always glad to get out. And I can empathize deeply with anyone who's ever had to spend so much as a day in jail. So there's this quantum of suffering that's set by the legislature, how much suffering should attach to this behavior. And that is the process of the sentencing. Now, of course, there's specific deterrence and general deterrence and rehabilitation. But really, we're there for this ancient and barbaric notion. How much did this person suffer? So I would appear in front of judges years and years ago, and I would argue, Judge, the last thing you want to do is put this young man in jail. Because putting this young man in jail, it's granted he made a mistake, he was reckless, he did not think this through. But putting him in jail teaches him how to survive in jail. And the last thing you want is him coming out knowing how to survive in jail. Judge, trust me, you will not have a better person. That argument was not particularly effective. I would argue, Judge, this young man needs a second chance. We just need second chances. I certainly, maybe, Judge, maybe I'm not the best example. You're a judge. Maybe you never made mistakes, but I made lots of mistakes, Judge. And I got second chances, and I'm glad for them. That worked a little better. Sometimes the judge would point out, Mr. Seaton, this is your client's third chance. I'd say, well, we need another one. Right? We need another one because there's some emerging brain science, Judge. Very interesting, just emerging. That young people, adolescents, don't even really have the ability to conceive of consequences until about the age of 25. And in fact, for males, it's like the age of 40. So, Judge, I mean, even biologically, they need second chances. We want to preserve this person because, frankly, once you tag them with that record, we're throwing him away, right? And in the state courts where judges still have discretion and where you can reach them and make them empathize, and the fact that I was representing almost all white defendants in front of almost all white judges, that argument had some effect. They would sometimes see that. Now, fast forward some number of years, you get these kids to 28, 30, 35 years old, and they do, for the most part, stop committing these reckless, negligent, impulsive crimes. But what's been really gratifying is to see how the law has begun to embrace some of these very concepts, that we shouldn't be so loose with handing out this suffering and this time that we hand out. That this era of mass incarceration has been counterproductive, and it's hurt us. And that's an argument I made seemingly into the wind for 10 years before it seemed like anything. And, you know, nowadays, when I argue to a judge, look, if punishment is necessary, let's titrate the dose down to the least necessary dose to achieve the effect without all the unwanted side effects. Right? Let's just do that. Because truly, if he is sorry, a month in jail has the same effect as 9, or frankly 18, right? I mean, he did cocaine and drank too much, smashed up a car, but let's give him a second chance, because as we know, he could be president someday. So that argument has gained ground. Judges no longer start yelling at you halfway through the sentencing presentation when you make that argument nowadays. Similarly, what we understand about young people and the way their brains work has changed. I mean, even prosecutors now sometimes cite this evidence to me. Did you know that 25%? Yes, concurrent with that. So is there an emerging trend that I see on my side of the law that's helpful? Yes, to some extent. Now, of course, I don't know how long it'll take the law to reckon honestly with the issue of race, and that's probably a whole day's topic. But at least in terms of the role of punishment and what criminal law can achieve, I see a hopeful direction. Now, get a little tight on time, but let me just add that every day after these labors in the vineyards of justice, where I was, you know, the chief cook and bottle washer, I would go home and watch news. And I would marvel at the fact that people who were reckless in poisoning a river, or negligent in allowing workers to die, or not careful enough to prevent dozens of people from being poisoned with food, seemingly could not go to jail no matter how hard they tried. And I could never reconcile that. My daily reality of begging for time on behalf of 17, 18-year-old kids. You know, judge, please don't throw around that concept of 3 years like it means nothing. You know what 3 years means? When this kid who barely can grow a beard gets to jail. Can I explain that to you? Can I explain how long 3 years can seem for him? With the fact that you could do almost anything on the other side and not land in jail. I don't know if that'll ever change. I listened very carefully today and I learned a lot. I'm still not persuaded that will ever change. But I think our notions of the value of human life, the value of each citizen, and the idea that rehabilitation, educating someone, and letting them grow up, getting them along like we care for them, like we love them, like we feel for them, like they're a member of our family, that is no longer a far-out notion. That's not just the realm of young, wild-eyed idealist defense lawyers anymore.
Okay, great. So let me start off with a couple thanks to Candy, Kelsey, and Jessica for inviting me, putting on an amazing conference, making the logistics really painless, actually. That was great. And then also for putting me on this panel. It's really going to make me look a lot smarter than I actually am by association and affiliation. Frankly, I'm like right now feeling a lot smarter myself. I hope that comes through. And the whole, this has been a lot of food for thought, hopefully for all of you as well. Okay, so I was told also to start kind of with an autobiographical connection, and I didn't realize people were going to go so far back with their autobiography. So I'm going to do a little bit of that too. I've always kind of had a strong sense or a strong passion around economic justice. When I was growing up, maybe like the most tangible example of that was that I really wanted to hang out with homeless people a lot, and maybe I don't even understand where such a strong desire and passion to do that came from, because that wasn't necessarily from my parents. They found it strange, bizarre, potentially unhealthy, and this is not surprising. I have a son now. I might also have some of those same feelings with him. I would sometimes lie to them, actually, ask them to drive me in from rural Maryland to Baltimore City to go to the art museum. But really what I was there for, and the art museum is great, but really what I was there for is to talk to Byron, the homeless guy who was there. I was about 12 or 13 at that point. And I spent a lot of time with him. Once they found out, then I had to go to more like acceptable ways of hanging out with homeless people, which is soup kitchens, homeless shelters, that kind of thing. I did a lot of that. I didn't have much of a social life in high school, and I was a nerd, but I like doing that stuff. And actually, I never really dropped it in college. I continued in Philly to spend quite a bit of time at various homeless shelters in West Philly, doing also some interesting, I don't know how to describe this, classes on philosophy, which is what I was studying in college. So then also that was formative for me in terms of economic justice, studying a lot of Marxist political theory and especially literary theory. And then I went to live in France. That's an eye-opening experience when you think that when I ended up realizing that I was actually conservative in my politics compared to the French or some of them in any case. So when I got to law school, some of it kind of drove what I did in law school, but not so much. Law school was a really busy time for me, as it is for all of you, and so I dropped some of that work. But I was happy to be able to come back to it, going to public citizen. Public citizen isn't necessarily an economic justice-oriented organization. We are a nonprofit public interest organization. Originally founded as a consumer rights advocacy and protection organization, but we have taken up many more issues, potentially too many if you ask me, especially these days, the issue about money in politics, getting money out of politics. One of the issues that we deal with and we fight for are regulatory protections for the public. So this stems from the consumer rights work. We feel that it makes a lot of sense in terms of policy, but it's also just the right thing to do for our agencies to be doing as much as they possibly can to protect the public in various ways in which the public needs to be protected. It's not just the public, it's the environment, of course, as well. And I know a lot of you folks here understand and care a lot about environmental regulation. Well, on Capitol Hill, not everybody sees it the same way. So a lot of folks, a lot of conservatives, think regulations just kill jobs. They don't really achieve the ends that they're supposed to achieve. And frankly, there's a lot of campaign money that gives them an incentive to push those policies. So I'm going a little bit of the scenic route to my intersection with white-collar crime, because most of my work has to do with making sure that Congress doesn't make it harder for federal agencies to issue public health and safety regulations, environmental regulations, financial regulations, like that. So where does the white-collar crime come in? Well, regulations are one thing, but regulatory enforcement is just as important. It's kind of like for all of you who have taken administrative law, you know that regulations come from authority under laws that Congress passed, right? But enforcement authority is derived from those regulatory standards. And if you don't implement a law into regulations, it's like the law didn't exist. Well, if you don't enforce the regulations, like the regulation didn't exist as well, right? And I mean, we see it every day, as Professor Taub was saying. I mean, the Wells Fargo example is wonderful, and the CFPB, who has been a very embattled agency ever since this inception under Dodd-Frank, is you know, I think people are realizing the importance of having the CFPB around with the Wells Fargo scandal. So there have been other recent enforcement scandals that have been very important for public citizen. And we've been distraught, frankly, by the lack of any real enforcement beyond just fines and deferred prosecution agreements, which I like to call criminal settlements because it's a weird thing, and I don't know how else to describe them. I'm talking about GM and Takata and all the deferred prosecution agreements on Wall Street, even VP Wellsville to a certain degree. For regulatory violations, reduced deterrence, I really believe, leads directly to cutting corners in the future. Corporations simply not feeling like they really are going to face any real fines, or if the fines are coming, or any penalties, and if they are coming, it's really fines that the shareholders will pay for, and not any breach of the corporation. So, what does this all have to do with the white collar push? What does the white collar push have to do with my work? So my work is very much Hill focused. I'm a legislative advocate, and one of the pieces of legislation that has was moving in with a lot of momentum but has stalled is the criminal justice reform legislation. And that legislation, I think when people think about it, they think mostly it's about sentencing, overcrowding prisons, that kind of thing. Well, that's and you have every right to believe that, because that really is what most people think of when they think of criminal justice. Well, some folks think it should mean making it harder for prosecutors to hold regulatory violators accountable under some statutory schemes where currently, in order to hold those folks accountable, there are lower intent thresholds. So we touched on them a little bit: the responsible corporate officer doctrine and the willful blindness jurisprudence, right? And so on the Hill, I want to give you a good kind of bird's eye view of what's going on the Hill with this issue, because criminal justice reform, sentencing reform was moving right along, and then at the last hour, in the last several months, there's been a push to insert something called default mens rea as part of the criminal justice reform push. Default mens rea would require, would basically change current law to a certain degree by inserting intent standards that then prosecutors would have to prove in laws that currently don't have those intent standards. It may have specifically been passed without those intent standards because that's what Congress intended. There's all kinds of policy pros and cons, I suppose, on both sides. Full disclosure, I don't think default mens rea is a good idea. But it has been surprising to see folks, supporters of mens rea, push it as part of the overall criminal justice reform push. They push it under a blanket move to reduce overcriminalization across the board. It wasn't something that has had the kind of bipartisan support and momentum given the massive problems with sentencing and overcrowding prisons that the sentencing reform had, right? The mens rea is kind of has generally been, while it's had some bipartisan support, it's been pushed by conservatives, conservative organizations and conservatives in Congress over the years, where sentencing reform has really gained this kind of bipartisan support. So it got the criminal justice reform push to a certain degree became a fight over this mens rea provision, where it worked out in kind of strange ways. You had a Senate Judiciary Chair, Senator Grassley, a Republican, basically saying, I'm so sick and tired of this no prosecution on Wall Street and all of these different prosecution agreements that I have no interest in making it harder to hold white-collar criminals accountable. On the House side, the Democrats who were in the minority, they were saying, well, if this is the price to pay for criminal justice reform, maybe we're going to have to go along with it, even if it's not something that we really agree with, because it's going to make it harder to go after white-collar criminals. And the White House now has played a very helpful role by basically blasting the proposal about as strongly as I've ever seen them blast anything. They have come out guns blazing, saying, we're going to veto this. We don't even care that it's that's not even close to voted to. We're going to tell you right now, we're going to veto it if it ever is close to being voted on. So going forward, in terms of Congress, we're going to get to the lame duck session, then we'll have the next Congress. There's maybe a small chance that CJ reform passes in the lame duck, but I wouldn't really bet on it. And it's still going to be facing the same headwinds that it currently faces. So we're talking about what was mentioned before, the Billy Horton soft on crime claims. That is also a headwind that's making it hard to pass criminal justice reform. And I think the mens rea issue will come back. I think it's also important for, in a broader, kind of addressing corporate crime agenda, it's important to put out kind of liberal or progressive proposals to go after white-collar crime. And I'll give you one example. It's called the High No Harm Act. It was introduced in the wake of the GM scandal. Essentially makes it it makes it criminal, punishable by up to 5 years in jail for a corporate executive to knowingly conceal products or hazardous working conditions, essentially. That's the type of thing that kind of reinserts the responsible corporate officer doctrine, or maybe more willful blindness back into the picture, and hopefully will make it harder for folks that are trying to push mens rea, make it harder for them to push that as part of criminal justice reform.
I also want to thank everyone at Vermont Law School for such wonderful hospitality. I've been meeting people whose work I've read for years, and that has been very rewarding. I'm the health, safety, and environmental person, and I sort of scurry along the tracks of the big financial folks. I write about activities that kill people, hundreds of people, and there's a direct line you can trace between the carelessness of businesses and people dying. I'm not questioning at all that the 2008 crash was the impact was very grave, but I do think that, and people may well have died as a result of that crash. It was so cataclysmic. But I actually can see the faces of I see photographs of the people who died, and it's very hard to forget. Just to give you one example, we've been going back and forth talking about large corporations, and then there was some suggestion that small fry, maybe it's not as serious. In my email this morning was a plea for help from an organizer for safe work. Apparently what happened was that one Harold Felton was crushed in a trench that was 7 feet deep and 2 feet wide in Seattle, and the organizer wanted help going to the local district attorney and trying to persuade him to investigate this as a criminal case. Now, we've known how to build trenches since Roman times. There is absolutely no excuse for anyone allowing a worker that's not shored and to have this kind of thing happen. 1 cubic yard of dirt is as heavy as a car. So you can imagine when the sides come down, what a gruesome and terrible death it is. And I frankly hear about these things fairly frequently. I mean, in fact, to their credit, the Manhattan DA has started a program going after construction companies in the face of accidents like this. Cyrus was persuaded to do that, which also shows it's a sign of hope in some ways, because it shows that we don't have to put all our eggs in the Justice Department basket. You know, we are working pretty hard to try and get communities to realize that local prosecutors are another source of relief. The basic fact of all of these cases is that so-called accidents, that's what they're always called, and the dictionary definition is that they're not foreseeable and they're not preventable. And everything is an accident. Accidents happen. In fact, if you delve into many of these incidents, they are absolutely foreseeable, completely preventable, and are caused by pressure from up the chain to get work done quickly, to ignore egregious warning signs. I'll give you a couple of well-chosen examples, but just for a minute, I'd like to pull the camera back 2 feet. I actually think that the disparate, the two justice systems that we're living in America, that you were describing, the kinds of, jail, you wouldn't want to spend 1 hour anywhere near it, and yet so many young men, young African-American men, spend many years of their lives in such circumstances, is at the core of what's going on in this country and what's happening in the election. The reputation of government is extraordinarily weak. It's shattered. And the justice system, the integrity of the justice system, has been shaken to its foundations. People are angry because of the income gap, because they see a hopeless future for their children, and the disparate way you treat street crime versus white-collar crime is one of the key factors that drives that. I teach in Baltimore. The Department of Justice just put out a report that said the Baltimore Police Department reported over 300,000 pedestrian stops from January 2010 to May 2015. 7 African American men were stopped an average of 30 times. Only 3.7% of these stops, which usually came because they thought you were in the wrong place at the wrong time or were doing something funny like standing on a corner, only 3.7 ever resulted in an arrest. And even when charges were filed, Baltimore Central Booking and local prosecutors rejected over 11,000 such cases because they lacked probable cause or otherwise did not merit prosecution. So in Baltimore, with the shooting of Freddie Gray, like many urban areas in this country, we're hurting. I mean, it's a very raw situation. It's tragic. And it's racial to its core. And when we think about bankers hiding in plain sight, with only one relatively low-level person pursued in this whole crisis, we can see why we're in trouble, I would argue, as a country, and we've really got to do something about it. So to get back to theory, because I am a law professor, Lawrence Freeman, who wrote The History of Criminal Law in America, always reminds us that there are 3 purposes of the criminal law. One is punishment. Professor Henning reminded us of this too. One is punishment, one is deterrence, and the third is to reflect community values. And that sounds flaky and mushy. It sounds flaky and mushy. But what it really means is the community's uniform rejection of behavior. And that is what we are deprived of when we have deferred prosecution agreements. Nobody ever admits they did a criminal act. And the Justice Department writes up this piece of paper in high dudgeon and puts it on the website. but it's a civil case, and that is very different than calling the behavior what it is. In my area, we have food. The most egregious example is the Peanut Corporation of America shipped tons of peanut paste that had tested positive for salmonella, shipped it out. It was incorporated into 3,000 products. People were so distraught that the FDA website got 27 million hits of people trying to figure out what they had to throw out that was in their pantries. The guy who was the CEO of the Peanut Corporation of America was sentenced to 28 years. And that belies the perception that if given to a judge, just a regular old judge and jury, that people won't be convicted. Drugs. Many of you have gotten steroid injections, or you've had drugs pre-mixed at a pharmacy at a specific dose for your children. The New England Compounding Center shipped out 17,000 vials of steroid injections that were contaminated with fungal meningitis. They killed 64 people. We forget this. We forgot this. Imagine what would happen if someone walked into a place with a gun and got down 64 people. The 751 remained ill, and when I say ill, this is fungal meningitis. You were really sick for a very long time. They were indicted for second-degree murder under RICO and have yet to go to trial for reasons that are entirely unclear, but this is up in Boston. Products, we've mentioned GM, Takata, Toyota, VW. VW installed a device that released pollution into the air that Harvard and MIT estimate killed 50 people and made the pollution much worse in this country. And that was so blatant. GM, they had an ignition switch that wasn't working. You could be driving along, and if you hit the key fob with your knee, it would turn off the motor, put it in an accessory position. You would lose power steering, you'd lose power brakes, you'd go into a moving stall. If you were driving along the highway, you might lose control of your car. It also disabled the airbags. And you know, the GM's admitted to 112 people being killed. It's actually likely to be in the final analysis much more. And to add final insult to injury, the people actually who were driving, some of them were prosecuted for reckless homicide because they were driving this car that wasn't working. And one of them had her record expunged recently because GM admitted this. When did they know at GM? They knew in 2005, there was an engineer who realized he allowed the car to roll off the assembly line with this defect that he knew existed, and he secretly re-engineered the part, but used the same part number. So all the cars which had the defect remained on the road, but the problem was solved for new cars starting in 2005, which I suppose is something. But boy, that fellow looks to me like someone who should be prosecuted and flipped. You know, even Mary Barra, the CEO of the company, has admitted that one of the reasons this happened is what she calls the famous GM shrug. At the end of a meeting, who's going to do something about this? Should we do something about it? You know, I don't know. We'll have another task force and discuss it. In the environment, we have BP. We have Freedom Industries, the company that let a big rust hole in its tanks and outleaked many gallons of a chemical that was used to wash coal. It got into the Charleston, West Virginia water supply. Turned out it had never been tested, so no one knew about the ramifications, what was wrong. And finally, the governor, a conservative Republican, announced that it was a personal choice whether people continue to drink the water or not, because he couldn't really tell them what the risk was. This is life without government. I mean, it's going to be your own risk analysis, you and your neighbor standing over the back fence. Workplace safety, I'm almost done. Upper Big Branch Mine, there was a horrific explosion that was largely caused by a combination of coal dust that had built up. Combustible dust accidents are hideous, and a spark because methane had built up as well. These are two of the most prominent dangers in a coal mine, and 29 men were killed. The explosion was, sort of an unspeakable thing. It traveled, miles underground, and it took a long time to sort of figure out where the bodies were and who had been injured. Another example, Texas City Refinery, where there was another explosion that killed 15 people despite warnings for months in advance. The plant manager even brought a PowerPoint with pictures of dead workers and showed it to the number 2 at BP and the head of North American Refining and pleaded with them to stop cutting his maintenance costs because he was having to let go of supervisors. And it all fell on deaf ears. And to make it even worse, the number 2 at BP had gotten a bargain price on that refinery when they bought it from Amoco, and he knew perfectly well that it needed hundreds of millions of dollars in repairs because Amoco had run it into the ground, had melted the plane. And if that's not some kind of knowledge, I don't know what it is. So the common threads in all of these things are greed and executive hubris. It's interesting to note that Sir John Brown, the head of BP, and Martin Winterkorn both wanted to become the biggest corporation in their field. So Brown's ambition was to make BP the biggest oil company. Winterkorn was going for biggest car company. He actually made it for about 2 months before the chief device was discovered. He outpaced Toyota. I was really surprised. Corner cutting in high hazard industries. Get the work done fast. Don't bother shoring the trench. Let the models roll with bad ignition. Regulatory failure. We've talked about this. The agencies can't police it. They're underfunded. They have no political support. Jesse told us about stupid policies at DOJ, failures to prosecute. I should have mentioned, just to be absolutely clear, GM got a deferred prosecution treatment even after that ignition switch fiasco. And stubbornly, finally, I would say stubbornly wrong-headed ideas about mens rea. I was really happy when Ellen said, reminded us about willful blindness, reckless disregard. These are states of mind that are much more applicable to corporate managers and executives than intent, conscious intent, because they ignore problems, they bury problems despite repeated warnings. Government agencies coming to tell them, as they did in the New England Compounding Center, that something was wrong with a dirty lab. The GM internal task force is trying to figure out, oh my goodness, our lawyers are warning us we're going to be assessed punitive damages in tort cases because this ignition switch is such a mess. Reckless, if the Justice Department would just go back and read its textbooks, because this has been around for a long time, these ideas, they would have a whole new fresh breath on how to pursue white-collar crimes in these areas. Finally, and my last point I promise, is weak criminal provisions. If you kill a worker through gross negligence, which is what I just described to you happened in Seattle, whoever was on that work site, whoever was the head of the construction company, killed that worker through gross negligence, because we know what needs to be done with the trench. You are face a possible jail term of 6 months and a maximum fine of $70,000. If you harass a burro, a wild burro in the national parks of the United States of America, you face 12 months. So, and this is something that Trump always reminds us of. So as Ahmed said, because we are twins in many ways, we work on the legislature, we're triplets. What we need is, affirmative, stronger laws. We don't need to weaken all this. We need tough, protective. All of these violations need to be made into felonies, and really, we need more aggressive prosecution.
Well, I'll start, of course, with the thanks that everyone has been giving, because they are well warranted. We appreciate it so much. We, of course, also, as the last group, always thank you for staying around to listen as well. What we've seen, in part, is the power of narrative, right? The stories, and it's critical to remember as lawyers, the power of narrative and the careful shaping of narrative. Often incomplete, to make our point, up to the other side, usually to point out the other facts not contained in our particular narrative. And that's the advocacy system in a very large part. I'll do two of these narratives, but I'm going to do primarily statistics. And then I'm going to do what's gone wrong, but to end us on a note of what we can do right. And indeed, I'm going to emphasize what we can do right under existing laws and with existing resources if we use them intelligently, as we have done in the past, but have ceased doing. So my first narrative is to attempt to bring together a number of the things we've been discussing. And this is deliberately, because I wanted this level of analysis, which is to say not much, from Wiki. All right? William Jardine, parens, merchant, close parens, born February 24th, 1787, dies 1843, was a Scottish physician and merchant who co-founded the Hong Kong-based conglomerate Jardine, Matheson and Company, right? And then it goes on to record how he becomes the most successful merchant in the Far East, and that he forms the top trading house in all of Asia. He's the model for Taipan type of thing. He comes back to England. He's elected as a Whig. That's the predecessor to the Tories and the Conservatives. This is the, we don't want the government doing much party, and then eventually dies in old age, but his firm continues to this day with relatives of his 200 plus years later, right, as this major construct. Now, how many people know who the hell Jardine is? Okay, this is a very educated group, and the fact that we don't know is a big part of the problem. Here's the similar entry for this guy named Pablo Escobar. You think it says parens merchant? It probably says what? Parens drug lord, right? That's exactly what it does in Wiki. Well, Jardine was the biggest drug lord in history. He controlled the entire opium trade, and he was famous and rich, and Jardine is famous and rich to this day with all those collateral relatives because he held the largest, controlled the largest opium cartel in the world. And he did this in complete violation of Chinese law. And when the Chinese dared to try to enforce the law, he said this was a violation of what principle? Free trade. I'm not making any of this up. This is not leftist stuff. This is, nobody disagrees with this, right? This is big time history. When they burned the 20,000 pounds, because they didn't seize it and take the money, they actually burned it so that because the number of people in China addicted to opium have gone from 2 to 12 million in a few years because of Jardine. Jardine went back to the United Kingdom, and as Wiki said, to urge forceful measures upon the Foreign Secretary. Now, the forceful measure was the first Opium War, right? I don't know if that triggers any memory cells, but the first Opium War was literally planned by Jardine, and I mean in detail. You said these vessels up these rivers, which have the following depths, are navigable to these points. You shell these cities, right? And the Brits followed his plan. This is the reverse privatization stuff, right? Where the British Navy specifically acted on behalf of the leading drug lord in the world and indiscriminately blew the hell out of Chinese cities, killing large numbers of people, innocent, right? I won't do the insanity of, well, who would be the guilty folks in all of this, but absolutely indiscriminate, women, kids, et cetera, and after that, he's elected as a member of parliament. So, not only is there, social stigma to criminologists is a really complex matter, and it varies enormously. This same person on any objective facts is among the most loathsome humans to ever walk the earth, and you would think would have social opprobrium. Instead, they're elected to high position, given all the honors, and continues their family centuries later, right? But I will tell you also, Pablo Escobar was also elected to parliament as a drug lord, right? So this is a very common thing that a number of crimes, far from having stigma, well, you have it with some sectors, but other sectors actually tend to love you. The second, I will build on a narrative to show you how awful people are willing to be for such small dollar amounts. So China has long had a problem with counterfeit infant formula. It's cheaper to make infant formula that has no milk products, right? You essentially put chalk in with water. This has been such a recurrent problem in China that they developed a test designed to prevent this kind of counterfeiting. That test looks for protein. And so the manufacturers of this fake infant formula added melamine. Melamine spoofs the test. This is a bit like Volkswagen. It's the second stage scam to spoof the test defined if you're engaged in a scam. So now you had a product that had zero nutritional value for the portion of humanity that most needs nutrition, and has a contaminant that causes kidney stones in kids as young as 3 months old. Now, I don't know if you've ever been around somebody with kidney problems, but it is excruciatingly painful, and can be fatal. It only killed 6 Chinese, according to Chinese reports, but it hospitalized 300,000 infants. Right? Now, our social prohibitions are at the absolute maximum when it comes to infants. And these people made a few $1 million. We are talking about systems where the CEOs make hundreds of millions of dollars, sometimes billions of dollars, and give out, bonuses to the officers that help them do this, billions of dollars. And they don't believe they're doing anything wrong because they've been taught that they're not doing anything wrong when they defraud people. That it's just business, or it's just negotiation. After all, it's not moral. Or it's taxes, and everyone's supposed to minimize their taxes and such. So morality does inevitably come into this issue in really important and complex ways that we can all just begin to give you a flavor of. We hope you will study it, in much greater depth. So I'm going to give you a few things from the white-collar perspective and the financial regulatory perspective that you haven't heard so much from those presentations that are, I think, relevant to overall topic. First, let me endorse what you just heard before me, and that is white-collar crimes kill and maim far more people than do straight crimes. But we often don't even think of them as crimes, even if they are crimes under the statutes. And we certainly don't prosecute. It's rare in all countries to have such prosecutions, not just the United States or the United Kingdom, countries like that. Second, if you've heard anything about criminology, and you're not a criminologist, probably the only theory you've ever heard is broken windows. So broken windows is this theory that you need to arrest people for minor status offenses so that you can get the community functioning well, so that more adults will be out in the streets later at night, and that they will perform the traditional functions of mom and dad and grandma and grandpa of making sure those idiot teenage guys, who are idiot teenage guys everywhere in the world, right? Males really as adolescents are a total pain in the ass, statistically, as criminologists. We're just awful. We are only variants of all, right? But virtually every male will have committed some crimes as an adolescent, is what we find in all societies, right? And of course, whether we actually get put into prison, or even the criminal justice system, or left outside it, is one of the biggest determinants in how our lives turns out. Guess which one helps the most? Not being put into the criminal justice system, of course. In the blue-collar street crime, you inevitably enrage the community. And when you add race or ethnicity to it, you quadruple this effect, right? It alienates precisely the people you need to have an effective police force. It creates some variant, they start doing war metaphors, and war metaphors are the bane of criminology. Anybody that does them knows nothing about criminology, knows nothing about effective policing and such. But they inevitably go down this path. Hey, in white collar, this would work really well. It wouldn't have to work even with criminal, as opposed to interventions to say, no, you can't dig trenches that way, right? If this happens, you don't do work again, right? Until you show that you've gone through the following training and you have 3 years without any such accidents, and then maybe we'll let you back into federal contracting. That's what I'm saying, departments and other such things. You can do lots of very sensible broken windows policies in elite white collar in particular, right? That would make sense and wouldn't, as I say, necessarily result in criminalization at all. But of course, we never do broken windows. We do exactly the opposite. We say, no, let them go to the absolute margins of despicable behavior that harm the firm. Harm the firm and harm society, rather than have any impact. Another principle from criminology that was this morning's discussion, it's the generation of moral panics, right? So yes, there's a whole literature about this, and if you like musicals, Music Man has the quintessential song, Trouble in River City, where he creates a moral panic by saying, there's a pool table that's come to this town, and the whole society will degenerate, and the women will start be dressing wild and loose, and the guys will become libertine men, scarlet women, to quote the song. This sounds silly. It is silly. It's reefer madness, if you're familiar with reefer madness. And it produces horrific results when it leads to mass incarceration, right? So this generation of moral panics, which is very much something done deliberately by political entrepreneurs, is something we have to get better at not allowing these things to happen. Okay? So we've talked a bit about the failures, but we've not talked much about the success, except Jesse talked a bit about everybody in the Enron era was prosecuted. They weren't. Maybe a fifth of them were prosecuted, because we don't hear about the other 4/5 because they're not prosecuted. But the number of restatements was massively greater than the number of prosecutors. When I say restatements, I'm talking about financial statement restatements because of accounting, well, let's be polite, abuses, but mostly fraud, right? The number of cases was far lower, but Jesse's absolutely right that as with the savings and loan debacle, there were very substantial numbers of convictions, and convictions of people who were very high in the food chain, right? And that has in fact stopped in the financial sphere. And that has stopped in the financial sphere, not just in this crisis, that stopped in the Enron crisis. Because one of the great opportunities to prevent the most recent crisis was Enron. Because Enron was aided and abetted by its frauds, and this was critical to the success of the frauds by at least 9 of the largest banks in the world. And they were caught dead to rights. Now, interestingly, they were not caught dead to rights because the banking regulators investigated, and not because the Justice Department, and not because the SEC. They were caught dead to rights because of the bankruptcy examiner. That process we haven't talked about. But unlike the dynamic which Jesse accurately described of these stupid Justice Department mandated, firm paid for reports that all read the same. Well, let's find a problem somewhere that can't be pinned on the CEO or anyone major, right? And then they spend lots of money and voila, they say, and we found nothing, at the top levels of the organization. Well, the bankruptcy examiner reports don't have that same dynamic, and sometimes they're much more honest. This one was, and it was earlier in the cycle of emails, so people were less careful. They didn't understand as much that an email was forever, right? And so the bankruptcy examiner got them, and they're just amazing. Again, and they're just amazing. So when we actually investigate, which is rare, elite white-collar crimes, and I mean really investigate as opposed to the crappy e-searches these days that the Justice Department relies on, which is immensely incapable of finding most real problems. What we find is that these guys, these elite white-collar criminals, will listen to the actual language on the Enron tapes. And then remember this: those traders who were making those statements knew that what they were saying. Okay, you get it? That's how bad. And then look at the equivalent, the IM messages and such out of LIBOR. They're just stunning in their depravity. I mean, the ability to make a case against these guys, if you really investigate, if you use real investigative techniques, like putting an undercover FBI person in JP Morgan Chase, you don't even have to change the resume. An FBI agent has a perfect resume to be hired by JP Morgan, right? Down this whole thing very easily, because Peter made one of the critical points. He said, well, out of the savings and loan crisis, I guess we'll never have liar's loans again, right? Excellent point to explore. Liar's loans were new. Liar's loans were brand new, and like all good frauds in America, financial frauds in America, they began in Orange County. And we happen to have jurisdiction over Orange County, California. They became significant in 1989, 1990, a long time ago, before most people in this room were born. Okay? Our examiners in the field were kind of busy with this thing called the savings and loan debacle, which looks quaint compared to today's crisis, but was widely described at the time as the worst financial scandal in U.S. history, right? Despite that, our examiners got it right, said liar's loans are when you don't underwrite, don't verify key information on a loan application, in particular income, the borrower's income, right? And our examiners said, look, this is inherently creates, I'm going to use some economics jargon here, adverse selection, and has a negative expected value. In English, that means you're going to lose money as a bank, right? And this only makes sense if the officers are looting the bank and running an accounting scam. And we said, you're right. And even though we're kind of busy with this overall savings and loan debacle, we wrote out a group of folks, and we went after every Orange County place that did, which we had jurisdiction on California, that did liar's loans. And virtually all liar's loans at that time were done in California, right? By 1994, the last entity still doing them, Long Beach Savings, gave up the ghost and voluntarily gave up its federal deposit insurance. Voluntarily ceased being a savings and loan for the sole purpose of escaping our regulatory jurisdiction. If they had this federal insurance, and if they were a savings loan. They became an essentially unregulated mortgage bank, and they changed their name. And some of you that know this crisis will know the role of AmeriQuest. But we actually did something right. In 1994, at this essentially contemporaneously, Congress passed OWEPA, Home Ownership and Equity Protection Act in 1994, which allowed the Fed, and only the Fed, to bar all liar's loans, regardless of whether there was federal deposit insurance. Okay? Now, the Fed by then had experienced that there were meaningful losses, that our examiners were right. The Fed by then had our entire experience with prosecuting the savings and loans. Over 1,000 felony convictions in cases designated as major by the Justice Department. And our cracking of the fraud recipe for these kinds of entities. So that the Fed didn't have to reinvent any of the wheel. But the Fed was run by Alan Greenspan. And Alan Greenspan, a protege of Ayn Rand, believed that fraud cannot exist in finance.
And can I add one little thing in here? He'd actually, Bill knows this, Alan Greenspan had recently written a support letter for Charles Keating prior to his.
Oh, Bill knows this real well.
As you know.
Yes.
Bill is the reason why Charles Keating actually, that's the story.
Well, it's sort of, so this is the switch. We could have prevented this crisis for this exact reason that Peter said. They reprised exactly the fraud techniques that drove the savings and loan crisis. They used slightly different ammunition. They used residential real estate, whereas savings and loan debacle was relatively more commercial real estate. So the ammunition doesn't matter. The fraud recipe accounting is the same either way. And they added secondary market, but that's actually not critical to any of these fraud schemes. I mean, you can't have liability. That's why we get all these settlements for tens of billions of dollars. right? You can only sell to the secondary market through reps and warranties, and if those are false, and you have potential prosecutions. Okay, so how can one succeed? Leadership, 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 committed to actually solving the problem. Simply got lucky. In the savings and loan debacle, when these techniques were new, where we couldn't simply look up in the books, how do these frauds work? The examiners spotted these frauds at an early time period. And the head of the agency, a very conservative Reagan appointee, simply listened to the facts, God forbid, and was convinced by the, in organizational terms, the lowest people in our organization changed his ideology, unlike Alan Greenspan, and said, this is a problem and we've got to stop it. So we don't simply have an example of how to prosecute, we have an example of how to stop a raging epidemic of this kind of fraud. At this period when it begins, when he becomes chairman, 300 savings and loans are growing more than 50% a year. That means with compounding, we double in size every 9 months, roughly. Right? All 300 of these are insolvent, are fraudulent, and dozens are entering every month. So the first thing we did is simply autopsy the failures. Good thing for legal skill. And we looked for common patterns. Something else we did that you may want to do if you're a lawyer. Don't eat lunch simply with other lawyers. We're in a federal agency. It has enormous expertise. Peter could tell you, I'm sure, very similar stories. I would have lunch with the accountants. I would have lunch with the appraisers. And I would have them teach me for free. They'd run a graduate seminar for free on these things. It's fabulous. You learn critical things that allow you to figure out how this works, and you build up a network. People have to trust you, right? They have to support you. This isn't won by individuals. These are won by teams. Yes, leadership from the chairman of the agency and folks like Mike Patriarch is critical. Got to be large numbers of people working together to combat problems remotely this large. You have to go to an emergency basis. You can't do business as usual. You'll be absolutely overrun by these things. So here's a test, a thought experiment, like Einstein would do it. You're in a room, and you're in a room with 5 US senators. Your insurance fund is massively insolvent. Congress is refusing to give you any more money. Kill your attempt to get money. Your only hope is in the Senate. And you're in front of 5 US senators, including the guy who is going to be the next chair of Senate banking. And one of those senators, and they're there, by the way, because they have Greenspan's lobbyists to get these senators to come to this meeting. And Alan Greenspan has assured the senators foreseeable risk of loss from Lincoln Savings and Charles Keating. And one of the senators, Deacon Seen, says, or asks, you believe Arthur Young, one of them the top 8 auditing firms, would prostitute themselves for a client. Now, 5 US senators ask a bureaucrat that, what is the only conceivable answer when I use the word prostitute? No. Mike Patriarch's actual answers, because I took the notes of this meeting. Absolutely, it happens all the time. You can succeed. You have to try to do great things. as people, and all of us has emphasized, none of these cases are remotely easy. Anyone who says it's easy to bring elite white collar prosecutions knows nothing or is a liar. It isn't impossible. You do have to start very low in the food chain often. You do have to follow things up. The more you have to ask questions, and comes to Ellen's point about shortcutting. We would convict many of these people because of the cover-up. They wanted to cover up the violation of the rule, and so they would lie to us. And that makes a very nice prosecution. People who are running these larger frauds out of running the business. So our top priority at all times was to get them out of control. We were regulators. Get them out of control so they couldn't increase the losses. Our second priority, once we've done that, was to get them convicted. Thank you very much.
So I'm going to have one question and then open it up to the audience, and then Jess is going to wrap things up for us. I guess a small statement before my question. I mean, so some of the things we've heard today about what to do, depending on how you define the problem, and maybe you see the problem differently. Some may see this as over-criminalization. Others may see this as selective prosecution. Still others may say the problem is using criminal law to deal with social problems. I've heard lots of different theories. Some things I've taken away so far is how important it is to learn to flip witnesses. And I don't know if folks know the word flipping, what people mean by flipping, going to a lower level person, getting them to, turn on the folks above. I've heard, I don't know if it was Mark or if it was Peter, maybe it was Peter saying, take their money. If you want to stop something, intercept the money, but I guess you would have to intercept enough of it so it's not just a slap on the wrist as we see with some of the banking. We've also heard about from Ellen the need for better prosecutorial oversight, better decision making, and maybe even statutory changes. There's lots we've heard today about the solutions, but I'd like to pose a question that Bobby posed and ask you to succinctly answer if you ran the universe, or not the universe, but some part of the universe, and could implement one change. I know you want to do more, but you just get one. And that change can't be, I get all the changes I want. Okay? I have a 9-year-old, I know how that works. So just succinctly, given what you see in your area as the problem, what would be the one change you wanted to make right now, with what you want to stop from happening right now? And I'll start with you, Dave.
I think what I take away today, and what has been my experience, is judges have to have discretion. Judges have to have discretion to do substantial justice, and their hands can't be tied in that way. Ideally, what that would mean is that they can take into account someone's circumstances that might have run them afoul of the law, and they can take into account is that someone else had not to run afoul of the law. I mean, I think what I take away is the importance of judicial discretion and honest judges from today.
Thank you. Rita.
Amit told me to say this, but I think it's a good idea. He wanted to leave you with thoughts as he ran out the door. But I would delink reform from mens rea reform. I think it's shameful, frankly, that there's been an ultimatum issued on that. If mens rea reform is such a good idea, it should be able to stand on its own. And mass incarceration reform is absolutely critical, especially given the very troubled racial relations in this country.
Thank you. And Bill.
I appoint Mike Patriarch ahead of the Federal Reserve and supervision groups.
Great, thank you. Okay.
What did you do, Jennifer?
I get to ask the questions.
You do have a 9-year-old.
Let me think about that. I wasn't prepared to answer my own question. Okay, question from the crowd. And where someone has the mic, okay.
Thank you. This question is for Professor Spencer. I'm sorry if I mispronounced the name. Where does Flint fall within the array of human-created disasters that you described? And the next question for any panelist. As a 3:24 p.m. Wikipedia defines white collar crime, refers to financially motivated nonviolent crime committed by business and government. I heard a little bit of the connection of white collar crime with businesses, but not so much about the government. So how big is it of a problem where we do have guardians of constitution and justice when they are inactive, or when they are inactive, they don't do stuff or cover up things that go on within the government?
I think that's a bad definition. Let me just say that first, because these crimes are very violent. And, I can show you pictures, but the government, deserves to be held to a very high standard. I do think, and as you know, the people in Flint, Michigan, the officials that allowed the lead levels in the water to rise have been indicted. I do think, though, that civil servants, it's very hard to be a good one these days. And they deserve much more respect and many more resources than they're getting. And I wish many things about the Democrats, but I wish they were able to articulate why we need government in a better way, because life without government would be pretty frightening. It would be, if there's a chemical in your drinking water, I have no idea what it is. It could kill your baby, but it's a personal decision for you to make, whether to drink it. I mean, a personal decision. Anyway, I hope that answers your question. I'd be happy to talk more about it.
And I can partially answer your question. And you typically in white collar crime, there's a section on bribery of public officials, and so that definitely falls within most people's definition of white collar crime.
Nonprofits as well, by the way.
Other questions? Yes.
Yeah, I have been a little concerned today to hear the emphasis on punishment without further conversation around what might be different responses besides punishment that may be more effective. And I want to say, I'm not a lawyer. I'm an advocate. But I was a lawmaker for 6 years, and so I'm very aware of the impulse on the part of lawmakers to increase punishments as a way of deterring people. I don't happen to believe that works at all. So I'm wondering whether it ever comes up in your worlds, the possibility, since we're talking about the future of criminal policy, because jails are a terrible place. That's the work that we do in criminal justice reform in Vermont here. If there's ever a conversation about a different kind of approach that wouldn't put people in jail, but it might go after people and say, no, we're not just going to fine you for the $1 million that's going to hurt your corporation, but you million gazillionaire CEO, we're going to take all your money, $20,000 in savings that the average American has to do with that. Does that kind of restorative justice, accountability, not meaning punishment, but real accountability, ever come up in your conversations?
Certainly comes up in the conversations. There has been exactly one case of an executive from the financial sphere required clawback that would come from her own resources, and it wasn't her. And that case was just overturned by the Second Circuit. So we were actually running a far more radical experiment of effectively decriminalizing and effectively removing any civil or administrative sanctions for the elite bankers. We've done those three things simultaneously. Like the world?
So I want to chime in too. It's interesting you mentioned this. William Cullen, who's a journalist who's written several books about this topic. He was a speaker at a conference I went to several years ago, and he reminded us that, and you may remember this was a time when the large investment banks were partnerships, and so kind of built in the economic consequences of making bad choices. In other words, instead of privatizing profits when times are good, you take a high risk bet and socializing losses when the thing inevitably collapses, they would have to feel that. So they watched their own money a lot better than other people's money. Now you're not going to be able to, they're now large publicly traded companies and responsibility because they, the clawback rules are fairly weak that were implemented, and we're not, as Bill mentioned, seeing success in the courts there. But there are arguments that there should be, as part of these settlements or deferred prosecution agreements, that why not take people's money away so that it actually sort of replicates that type of partnership arrangement, and maybe they'll mind the story a bit better.
And since I've been married for 36 years to an academic whose colleagues have just written the new book on it, I will mention better banks and better bankers.
Claire Hill and who's the other author? Richard Painter.
So that I can go home and not get.
Yeah, I would just add, first of all, that a clawback would be an amazing punishment, and I would embrace that every minute as an alternative to jail. The other thing that we should be doing, and it's so simple, it's called the nuclear option by defense attorneys, and that's to cancel government contracts, as Bill mentioned. I mean, why should we be spending our taxpayer dollars on a company that is, a stop law? With BP, it's the first time in recent memory that a very big corporation that had done something very public that was wrong was debarred, but only for a period of a few months. And the main reason the debarment was removed was because the British government came and said, you can't do this, all our pension funds are with BP. So, in a global economy, it gets very complicated.
And they do this to local, you often hear about a local liquor store that fails to card and someone comes in undercover or sells cigarettes to a minor. They shut the bar down, they shut the liquor store down for a month or two. Really, they feel the pain, and that sets an example. Yeah, I don't know why we can't do it.
Oh, well, wait, it's actually worse than that, and Jesse's book probably talks about this. In finance, the default is that you are excluded. So they have to get special permissions, and it's gotten so bad that CFTC is trying to do sort of a global, under the table takeaway from it, rather than enforce any of these sanctions.
Well, this goes back to that expression that personnel is policy. If you put in place people at SEC, CFTC, the other agencies, the Fed, who said, well, the default is you lose the ability to do certain things, you lose your privileges, people who won't waive it. I mean, it just takes, you talked about courage, it just takes a little courage. Another question?
That's why I said patriarch.
Yeah, I have sort of a big picture question that I'm not even sure is really a valid one, but I guess I'm hoping that you can confirm or deny my view here that there's sort of a displacement of prosecution where, because we choose not to prosecute the top level executives, we have to be siphoned up to the top and out of, and so we then inherently go after crimes that are easier and more simple to prosecute, but which actually cause much less harm. And so the poverty causes the crime, which causes the prosecution at the lower end, as we heard this morning. But actually, if you were to prosecute the high end of the economy, you might have the result of then defeating crime at the other end. Is that valid?
Yeah, I think that if you put together some of the things Ella's been saying with some of the things we've been saying, that's exactly the point. Simultaneously, you can have a failure to prosecute the elites and prosecutions that are overly aggressive as to people that have very few resources. So indeed, I've been of late doing pro bono defenses of Dick and Mary cases in mortgage fraud. Because it is so bad, the FBI's official site purports that mortgage fraud is often an ethnic-based crime. Particular ethnic groups that it claims are more likely to commit mortgage fraud. There is zero evidence of that. Zero. And yes, so these statistics are from the St. Louis Fed, which is which is the most conservative economically Fed. The wealth loss during the crisis for Hispanic households where the head of the household, I know that's dubious, it has college degree, is 72%. The loss in wealth is greater if you have a college degree than if you don't. And for blacks, that's also true, and the figure is 60%. For whites and Asians, it's the reverse.
There's no such thing as an invalid question. Now it's a very valid one.
Thank you, Alexa. I see a hand, is there a hand that open?
And my question kind of is tied in a little bit there also, and that is that, you know, I look at BP, I look at the second BP. The first one where the victims all went in and asked the court to appoint a monitor, and it wasn't done. And then we had where a lot of people were killed as a result. And my question really is that, are we using a backward approach to, in our policy of criminal justice, that we're being reactive as opposed to proactive? And should we be focusing on things like computer crimes right now to be more proactive?
Well, I want to jump in. I think that the criminal law is inherently reactive and always has been, in that any line prosecutor at any level will tell you, if something bad enough happens, someone's ass is going to get prosecuted, right? At the normal level of us mortals, if something really bad happens, someone's going to get prosecuted. I think the rub is, there seems to be a level at which that's not true. The problem. Somebody ought to be prosecuted. It is not a scalpel. The criminal law is not a scalpel. It's a fairly blunt instrument. But that, at least it ought to be wielded with some equity.
No, you can be very proactive in finance. You can change the compensation system, which is what is driving a great deal of this fraud, and simultaneously affirms, right? There's a really strong literature on this. That's a win-win. That's not criminal response, but it would dramatically reduce the amount of crime. And I will tell you, the best estimate of economists is the current crisis driven by these three massive fraud schemes is going to cost $24.3 trillion. A trillion is 1,000 billion. It cost 9.3 million American jobs. A million that would have been created that weren't created, and those effects on blacks and Latinos. Wow. So they will always play white collar crime off against each other. If you want to be proactive, you need to restore the FBI agents lost the white collar section and substantially expand beyond it. And then your point and my point, prioritize that which is truly damaging.
I think that the opportunity presented by the Yates memo, which unfortunately I think the defense bar is trying to do the same thing to the Yates memo as was done to the Thompson memo, which is to force them to retract it. But the Yates memo, the opportunity there is for the Justice Department to explain in broad terms what it considers to be a company that is conscious of wrongdoing and is taking proactive moves to prevent it. to offer such guidance, at least people would have a place to start, and that would be proactive and hopefully. That may sound naive. I admit.
Other questions?
This both speaks to crime from more of a, I don't know, poverty's perspective with Blacks and Latinos being incarcerated, and also like white collar. So I would like to know your thoughts on the business of prisons and whether or not that pressures governments, prosecutors to arrest Blacks and Latinos. It also influences legislation to, more frequently prosecute petty crimes that don't make like a huge impact on society. Then I also want to know like your thoughts on the revolving door in the corporate world, where a lot of high-ranked officials, people work for the FBI or become the U.S. Attorney General, like Eric Holder, tend to be a little bit more lenient on businesses because, once their term is up and they no longer work in government, they want a job to go to, and door plays a role in white collar crime and the business of prisons and that impact on vulnerable communities. I would like to know general thoughts.
I'm gonna take a pass on revolving door because I think Bill wants to do that. He's much more probably well informed than I am. I will say about the prison thing that the reason we finally gotten to the point, very blood-based coalition from the far right to the ACLU and the NAACP Legal Defense Fund, is because local governments can't afford prisons anymore. And we waste huge sums, billions of dollars on prisons. They're very expensive. The average prisoner costs $30,000 a year. It's higher in some states. It would happen if you actually gave the person that money to be educated or to help his family. Anyway, I think there is some hope there. It's not that, it's that their private prisons are a serious problem, but they still come from the same, they cost the governments that then can't do other things. And I feel hopeful about that.
I mean, the Correctional Officers Union in California is one of the most powerful unions in the state, lobbyists in the state. Incarceration for 35 years as a business proposition, but it's bankrupted everyone who's tried it. I mean, we're only talking about reform now because that's failed.
Yes, and because it's so expensive, they can't cope.
It's unmanageable. Even Texas is talking about
right. Even Texas. I mean, come on.
I'm not as concerned about the revolving door as many people. And I refuse to revolve. But our most effective top counsel was Harris Weinstein from Covington. But he came over with a mandate from the first President Bush, and I quote, because the head of the agency told me about it in person, to put prominent heads on pikes, quote unquote, right? So go after the worst frauds and just smash them, right? That was the instruction. And Harris Weinstein is just a very good lawyer. And so, if that's his instruction, he went out and did it. And his boss, Tim Ryan, went out and did it, but had the reverse problem of a revolving door. So Tim Ryan, what he did is in his instructions to the letter. Unfortunately, that meant bringing an enforcement action against the president who appointed him, son, Neil Bush. Mom, and Tim Ryan will tell you openly that he is dead. He's Republican oriented. he cannot serve again in the public sector because the Republicans will never appoint him. Now, so he served prominent roles as a lobbyist running the big trade association in securities. You know him, Peter, I say.
I'm just smiling because I heard you. Okay, other questions? Great, I'm gonna invite Jess up here to say some final remarks, and let's thank our panel. Put your hands away because we're going to thank again, just thank you to all of the panelists who made this day so special. We give them one more round of applause. This has been an incredible day, an incredible group of perspectives. Thank you all for your energy. And thank you for translating very complex topics into accessible presentations for folks who may have come into this room not knowing about white-collar crime or not knowing as much about mass incarceration in the United States. So thank you for sharing your perspectives with all of us. I think that as we leave from this room, from the time that I welcomed you here this morning, I really like Mr. Black's question. He said, what can we do? What can we do now as people who are going to be future citizens, future attorneys? And just to sum up some of the things that I heard today that I thought from our panelists were really cool. The first one was the quote that we got from Mr. Osler where he says, there are no futile speeches. And I loved how this ran throughout the day. And it was also followed up in Mr. Stevens' speech, speeches. And so it's our job to be advocates, to honor human dignity, and not to be afraid to be anti-insanity. I think that is, and you can succeed if you keep trying to do great things. So thank you to our panelists who brought that to us today. In addition, I need to thank a couple very special people who made today happen and worked very hard to bring all these great ideas here for you today. And two of those folks are Professor Taub and Professor Stand, who are our moderators. Great moderators and even better mentors. So as folks who've had them as professors here at BLS, thank you for having the faith in us and bringing all these great friends and wonderful people here for us today. Thank you. Additionally, our contributors, I thank them in the beginning, but again, that was the Chittenden Regional Correctional Facility, the Northeastern Correctional Facility up in St. Johnsbury, and additionally, Mill River Union High School. So I just wanted to note that they were here today as well. Finally, two folks who all of our panelists heard from a lot and who coordinated this symposium over 3 different time zones while being away from BLS over the summer. Skype dates on Sundays, nothing was too great a task to ask of them, and it's very important that they were highlighted in Scholastica for the work that they put into this symposium because they did such a good job even while they were in Alaska and doing incredible work making this happen. So Kelsey Bain and Candy Spindler. Round of applause. Thank you all for being here. We will have a reception at the Fox Inn at around, doors open at 4. We'll be there just a little bit after that because panelists don't run away. Please join us up here. We're going to round you up for a photo. Thank you all and have a wonderful day. Yes,
You let me know I'm going to the restroom, so I'll be back.
Oh, I got that really nice email from you, so I'm like, okay, what's going on? Oh, no, I wasn't, you know, camera's too long. Oh, yeah, no, I was.